Good evening, everybody. This is the August 8th, 2024 meeting of the Nantucket. This is the August 8th, 2024 meeting of the Nantucket Conservation Commission. I'm the chair, Seth Engelborg. The first thing we'll be doing today is establishing a roll call of our members. So let's just go from right to left. Mike Miserelli.
Here.
Here.
Tim Braid.
Here.
Linda Williams.
Here.
Joe Plandowski.
Here.
John Schaefer.
Here.
All right.
You're here.
I said I was here at the beginning, but thank you. I am here. So this meeting is happening in a hybrid format with some participation in the room and some via the Zoom. We'll be monitoring public input from Zoom and from the room. So if you would like to chime in, please do so. We don't have to say any of the script anymore, which is good for everybody, but mostly for me. And turning to our agenda, we have two continuances today. Under notices of intent, we have Sconsie Beach Preservation Fund at 59 through 83 Baxter Road, SC 48 3759, continued until August 22nd. And under amended order of conditions, we have 13 Commercial Street LLC at 13 Commercial Wharf, SC 48 3563, continued until August 22nd. So we'll turn to the first item on the agenda, which is public meeting, public comment. This is for items not on the agenda today. We will be following the select board's rules for public comment. If you would like to comment, we ask that you keep it to 3 minutes or less, and we will not be engaging in discussion related to that comment, just simply noting it. Is there any public comment from people in the room to start? None. Is there any public comment from anybody on Zoom? Can somebody bring Burton Balkind over, please?
Thank
Yes, go ahead.
Alkeberg. Burton Balkind, speaking as president of the Nantucket Coastal Conservancy. And I know our attention today is on the new NOI, but I want to bring some attention back to the geotube installation that has had a removal order and has not had any mitigation sand put on it in almost a year, and has had no data as far as monitoring in more than that period of time. With that, I like to say we are increasingly concerned about the state of the public beach below the bluff in Sconset. Since the Conservation Commission is Nantucket's regulatory body charged with upholding both local wetland bylaws and state Wetland Protection Act, both of which protect our island's wetland resources, including coastal beaches, we respectfully request that you take immediate action to address this situation. As you know, the stretch of shoreline below the bluff, parcels 48.8 and 49.9, are legacy to the citizens of Nantucket from the proprietors. Because of the installation of the geotube coastal carrying structure on the beach and a 2013 temporary measure that was necessitated to abate an emergency, which immediately destroyed the part of the beach, and the subsequent lack of mitigation, maintenance, and monitoring, our beach is slowly and surely eroding away. In fact, one expert stated in November 2022 that given the current rate of erosion, the beach seaward of the geotubes lost within 10 years. 3 years ago, on June 30th, 2021, the Conservation Commission found the project had failed and voted to issue a removal order. In September of 2022, the removal order was upheld in Superior Court. The permit issued by the CONCON for the installation has since expired as a license issued to the town to the permit holder. Yes, we are aware of the original permit holder, the private owners of Baxter Road, as well as the town have applied to expand the geotubes fourfold, and that you are in the midst of that public hearing on that application. However, the new application for expansion does not obviate your responsibility to do what is necessary to protect the coastal beach in question. Action is needed. None of us wants the legacy to be the disappearance of this beach. Do we? Please put this matter on an agenda for an upcoming meeting. I appreciate your time. Thank you.
Thank you, Spruce. And we are aware of your comments and also of the letter that was sent in by Ms. Atherton to a similar vein. We will discuss it at a commission and staff level at a later time and proceed as warranted. Is there any other public comment on Zoom? Yes, somebody bring Dr. Kriebel over, please.
Should he be speaking under public comment?
We will
He
ask.
shouldn't be.
Dr. Kriebel, is your comment related to an item not on the agenda, or is it related to the geotube filing on our agenda?
It's related to the geotube filing.
Okay, please wait. Anybody else? Okay, so that will conclude public comment, and it will bring us into our public hearing. The first item in the public hearing is the Sconset Beach Preservation Fund at 41 through 119 Baxter Road, SE 48 3736. And before we get started in earnest today, I, in my authority as chair, think that we should focus on two issues. The first is that we do have a, albeit minor, but we do have an update related to the council, special municipal council. And then the other item will be to begin to discuss conditions related to a potential order and sort of go through them and see what the commissioners have to say. So as a matter of update regarding the first item, the council, the town manager has signed and authorized a letter of engagement between this commission and Beverage and Diamond. That letter has been circulated to commissioners, but needs to be recorded for the public. That being said, we have not had any future or any additional discussions or engagement with them beyond that at this point. So we're hoping to have that for a subsequent meeting. Any questions? Yes.
I couldn't remember, because I know at one point Ian wanted a fifth question, but for those who don't remember what the questions are that we're asking council, I have them. Don't I just read them so everybody knows what they are? Because I couldn't remember.
Sure. With respect, those questions are actually in the engagement letter that was signed. Did people all have a chance to review that?
No, because it
Okay.
came too late.
Go ahead and read the questions,
All right.
and I have an answer related to the other question as well.
Okay. One, does the final action taken on SE 48-2824 on September 2nd, 2022, which is the original one, which you guys were on for, when the Superior Court affirmed the Commission's removal order required that this rehearing limit be discussed regarding this application's eligibility for review? Two, how do the requirements of the previous and existing MOUs and license agreements factor into the review of the application, which is the new one? Three, how does the current removal order and ongoing lack of compliance with sand mitigation impact this NOI submission? Four, do the engineer notes in the removal plan documents carry the force and effect of law, and how does that impact the new NOI? It's all revolving around procedural.
Thank you. And just before we get too far, I forgot to do what I wanted to do in the beginning, but Mr. Schaefer, unfortunately, this application was opened before your time on the commission started, so you're not sitting on this application, but you're welcome to stay and listen and learn, because it's likely that additional things in the future you'll have to sit on. Jeff or Will, do you have anything to add related to legal counsel?
No, I just wanted to make sure you guys got a copy, and we'll post that up. We were just clarifying that all the pieces of that weren't, any of it wasn't subject to any sort of attorney-client privilege, and that seems to be okay. So we'll get that up and posted for everyone, probably tomorrow morning.
I have one other question.
Thank you, Jeff. Yes, Linda, what's the question?
My question sort of tracks back to what happened 2 weeks ago. It's my understanding, through you, Mr. Chairman, to staff, that if we close the public hearing today, we can still converse with our attorney.
As far as my understanding goes, any matters conducted under attorney-client privilege are obviously not necessarily part of open meeting law requirements. So yes, you can always get legal counsel after public hearings are closed, or as part of your deliberative process, you can take an advice from your legal counsel.
Cool.
I would just say, and as a matter of procedure, if we do close the hearing, what no longer is allowed to happen is discussion with the applicant or any members of the public. It becomes just the commissioners. So I know obviously at some point we have to close this hearing, but I don't want to do that before we have this open discussion of conditions because it's going to inform the process. Anything else on that? Okay. Our prior chair, Ian Golding, at one point had posited that an additional question beyond the 4 questions that Ms. Williams read should be getting clarification on the status of the pre-1978 homes, particularly in light of the trying to find the regulatory history of the date that went into the Nantucket bylaw, and to get some opinions on the gap lots and other issues that are out there. I know the applicants given their opinion on case law, and I've given mine, but that was Mr. Golding's idea at the time. Yes, Linda.
I think the majority of us said we didn't need to ask that question already.
Okay.
'Cause
Joe.
It came up at that meeting, and then there wasn't enough support to actually add that question.
I don't
at the
actually,
time.
I don't actually remember it that way, and
Well, the
luckily,
three of us, I know.
luckily everything is recorded so that we can go back and look. I don't ever believe that we got to a motion that was elevated to the select board, but I do believe there was some support for that. So what we're going to do is we're going to go and see if there's support, and if there's not. And if there's not, then that's how it goes. And if there is, that's how it goes. Mike, how do you feel about this?
Procedurally, I would be fine getting that question answered.
Okay, Tim?
Excuse me, I don't really think it's necessary. Okay. I don't think it's necessary, but I'm not against it.
Okay, Linda, anything else beyond what you've said?
I'm against it, and I don't think it's necessary. I think we've asked and answered this through a bunch of testimony, and I don't need the answer for it now, because there were 3 or 4 of us that were opposed to it the last time, but as you said, whatever it goes now. But I'm against it.
Yes, and Joe?
Can you clarify exactly what we're saying?
His light's not on.
You have to turn the microphone on, please.
Can you clarify exactly what we're saying yay or no to?
Yes. So, well, first of all, I am strictly saying what Mr. Golding said in the past, but we don't have to merely adopt what he wanted. We could change it or add it to in whatever way we see fit. But the discussion was related to trying to get legal clarity on the gap lots and the pre-1978 afforded protection that the applicant is claiming 100% of the lots in their proposed area. Actually, that's not true. 100% of the lots in the reach 1 of their, or in the phase 1 of their proposed area are afforded to. And the thinking at the time was there has really not been any case law or finally resolved administrative information as well. There are some DEP filings in the past in the Commonwealth where gap lots were permitted. There's some where they were not permitted. There's some examples on Nantucket where DEP permitted them in superseding orders, but the local conservation commission did not permit them. So the regulatory history is a little bit complex, And the applicant is clearly stated that they believe that gap lots qualify for protection. The previous chair was hoping to get legal clarification on that. And that's what we're seeking to see if we want or not.
I agree that the gap lots ought to be included
Right, now I can
Included
proceed.
in what?
in whatever is being done with the law firm.
All right, I have a question.
Okay, hold on.
Yeah.
So, yes, Linda, go ahead.
There was a lot of problems, and to you, Mr. Chairman, Jeff can back this up. There were a lot of problems with town administration with this contract in the first place, which is why it's taken so long. And Libby was reticent to sign it. It was a very limited contract. It was limited to what we had voted before, and that's what was presented to him. The language about and any other questions that we may have, I believe, was taken out of the contract. So I haven't been able to review it completely.
Actually, before you go, I'd like to.
Yeah,
butt in
so
here.
that's why I'm concerned about now adding more to the contract when it took so long to get it in the first place, based on just this limited request. So,
Yes, so
Yeah.
we are obviously aware that any questions that are not in the original 4 questions, the process is that a motion of this commission in the positive needs to be authorized, and then that motion has to be given to the select board for their additional authorization to add a question. So that's what we're possibly trying to do tonight. We might decide we don't even want it, or we might decide that we do want it and the select board says no, but that's how the process goes. Jeff, do you have anything to add?
Oh, sorry. No, that's correct.
And with respect, I don't think our job is to decide how we should seek legal advice based on the difficulty of getting that advice. If we were going to do that, this whole contract has been extremely difficult to put into place anyways. If we were going to base it strictly on the difficulty, then we would seek no advice. But that isn't how we are operating here. That's not our regulatory responsibility. Our regulatory responsibility is to have the most complete information available to us in permitting projects so that we can get it right.
well, I'm worried, Mr. Chairman, about,
Yes, go ahead.
I'm worried about that delaying it even further, because they're meeting every other week now because they're on their summer schedule. Libby has been sort of on the mend from something, and she's not in the office all the time, though she's responding very quickly by email. And because of the reticence to sign it in the first place, at $25,000 for 4 questions, which are procedural, which town council has weighed in on already, I doubt the answers are going to be much different on a procedural matter only, not the merits. That I think if we start monkeying around with this now and add one, which we have to go back and ask, and then is that going to require another $5,000 per question, which is basically what it is. Actually, it's more than $5,000 per question. That's $6,500 per question. Now I got a problem again, because they may not agree to answer that question under the limited contract that Libby was able to sign and took some of that other language out that we can add, which is not there.
Thank you.
So
You've
I'm
made your
concerned,
point clear.
very concerned that we're starting down this road again.
Thank you. You've made your point clear, and I hear it.
I think Tim has his hand up.
I see it. I hear it loudly,
Loudly.
but the ultimate decision is going to be based on whatever everyone's thoughts are. So, Tim, go ahead.
Yeah, now that you've clarified it, I don't think it's important enough to delay us any further, so I wouldn't be in favor. Revise
you.
what I said.
Thank you. And I
So-
will, yes, I see you. I will just say to you, or Ms. Williams characterized the 4 questions as procedural. This potential 5th question is also procedural. It's not somehow a merit question. They're all procedural questions. Yes, Joe, go ahead.
The issue with the gap lots, I originally thought if you had a gap lot, one gap lot between residences, it'd be fine. If you look at Reach 2, there are as many as 3 gap lots. And somewhere, somebody you would think might make a decision on what's a gap lot. Is it 1 or is it 3 or 2 or 5?
Thank you. And just again, this is truly a procedural issue. We can get, if we got that question before the council and they gave us an opinion and they said gap lots are not permitted, and we thought it was important to have continuous protection of the shoreline, we could still do that by applying a waiver to this project because it was needed. So this is not a merit question, this is a procedural question. Do any other members of the commission wish to weigh in? Yes.
Thank you,
Go
Mr.
ahead.
Chairman. In light of it being a procedural question, I'm not going to be in support of it. Thank you.
Okay. Does anybody like to make a motion in support of adding that question? All right. That being said, I think we are concluded in the legal piece of the discussion. So we'll move on to discussing an order. Ms. Moldenhauer and Mr. Nyland, I saw your hands. Do you no longer wish to comment?
Yeah, the Chip Nyland here. No, I was just going to comment on the additional question, but now it's not going forward, then I don't have a comment.
Okay, thank you. So, in relation to the order of conditions, the staff has prepared a potential positive order, and it has since been revised. Did all commissioners have a chance to get the revised version?
What's the date on the revised?
It was today.
It was today. I posted it up today. Sorry, it was
No, this is the one I got from you today, right?
correct. It's
Okay.
the one I sent around today, and I posted it up on the town website today.
And can we get that up on the screen, please?
I'll let my
Yeah, that's the one I created.
partner in crime post it up on the screen for everybody.
Before we get started, I believe before representatives from SPPF said they didn't really wish to add at this point, just wanted the commission to deliberate, but is there anything that you do wish to say before we get into the discussion here?
Well, I think Chip Nyland here, generally, several months ago, we were willing to continue meetings because, time was our ally, but time is now our enemy. I think the concern that we have is the urgency to get a decision from the commission so that we're able to go forward and do some work before this winter season. I agree with the discussion at the beginning of the meeting with respect to the maintenance of the existing pilot project. That's part of this proposal. So, in addition to the extension of the geotubes, we also need to maintain the existing geotubes. So, extending this for any reason, whether it be going to the select board or adding a question, does nothing but harm the ability of this project to protect the area in 2024. So any discussion that we're going to have tonight, and any discussion with respect to the order of conditions should keep that in mind. We believe that we should be able to conclude the discussion today and close the hearing so that we can get an order of conditions and see where we're going on this, because otherwise we're not going to do work in 2024 and we'll have lost another year. So that's our general view today, is that we're hoping that the commission will get through this order of conditions and allow the deliberations to be completed so we can get an order of conditions issued.
Thank you, Mr. Nyland. And I'm going to speak very briefly on this point because it's a little bit outside of our process, but the ability to do work on this project in this year, it's not possible. There are other requirements that are needed before you, including getting authorization of a town meeting for work on the public beach, getting the select board to issue a license agreement. It is physically impossible for this project to happen in this year. That's all I'll say because it's outside the commission's jurisdiction. But some sense of, I understand the sense of urgency to want to get it done, and I'm not here to delay unnecessarily. But the commission is going to take its time appropriately reviewing the conditions, having substantive discussions on how those conditions need to be changed, and it may take several meetings. So I request your consent to that, because that is the process that we need to do. We treat all applications with the same amount of robust discussion, and there's already, I think, 55 special conditions on this that are going to need a lot of discussion, so it might be a little bit of time. Thank you.
Can I ask a question through you, Mr. Chairman?
Yes, go ahead.
Jeff, which are the sections that were modified from the original one that I read 2 weeks ago? I'm pretty sure I know which ones, but were they 16 and 18?
No, so real quickly, I can tell you the ones that changed is I had inadvertently left out coastal dune as a resource area up in the findings section, and I do apologize. I know we received some suggestion. Hey, Will, can you put it back on the screen?
There you
No worries. So,
Yeah, let's just finish
go.
this
Hang
first.
on.
well, so we included in the additional findings section some of the information on coastal dune. I know there was a request of maybe condensing those. I think we recommend against that because they have different interests and different findings under the state and local act for those, but we'll get into that later. The only other section from our notes from last time that I changed is I took out a condition relative to phase 2 and broke that out into a group of 2 separate conditions, which kind of enumerated some of the requirements that were discussed by the commission. And those new conditions in this draft would be number 42 and number 43. And that 43 has parts A through H on it too. But those are the only 2 changes from the original draft.
Thank you. Yes, Mike, go ahead.
Thank you, Mr. Chairman. Just so for my benefit, so I can figure out where we're going, and also for the applicants and for anybody who's in the room and interested, we can still close the public. We can close the public hearing and still deliberate the order of conditions for the time it takes us to do so. Correct?
Sort of. Once we close the public hearing, we have a limited amount of time to issue the order of conditions unless the applicant consents to us holding it over for longer. But I believe was 21 days that we would need to issue it.
Correct. Statutorily, from the end of a public hearing closure to issuance, the commission's required to do that within 21 days.
Thank you, Mr. Chairman. But the applicant could say they want to close, and then we have to have an up or down vote, no matter what?
Yes, the applicant is within their full rights and authority to say they want to close right now without us even discussing any of these conditions. I would not recommend it because we don't have I think not having the discussion in front of them is going to lead to conditions that they probably don't want, but they are well within their rights to do that if they please.
Thank you for the clarification.
Okay. I see you, Mr. Nyland, and I will go to you in 1 second. But before I do that, I'm going to explain how I think the easiest way to do this process is. So taking a page out of town meeting, the Madam Moderator would be happy with me, but I think what we're going to do
Could be risky.
is we're going to go through additional findings. We're going to count off all the numbers. And then if anyone has any issues with those numbers, I'm going to write them down. Then we're going to talk those numbers, and we're going to see what needs to happen there. And then we're going to go through the general project conditions, do the same thing. And then we're going to go through the special project conditions and do the same thing.
Do they get to comment as we go through?
They will
Okay.
have a chance, yes. Does any commissioners have an issue with that?
It's the only way to go.
Do the staff have an issue with that?
I think that sounds like an extraordinarily efficient way to do this.
Okay. Mr. Nyland, please go ahead.
They're so organized.
I just want to let you know I am not going to move to close this before that discussion.
Thank you very much, and we appreciate that. So here's, here's what we're gonna do. I'm not, for the sake of everyone's benefit, I'm not going to read the findings, but I'm going to say the numbers. If you have any numbers that you want discussion, please raise your hand or just call out the number, and I'm going to write it down. Number 1, related to the resource areas. Number 2, related to the NHESP habitat. Number 3, related to the protected interests. Number 4, related to additional protected interests. Number 5, also about protected interests of the bank. Number 6 is about protected interests of the beach.
Can
Yep,
I go back to number 3?
go back, yes.
Flood control.
Okay, I'm just going to write it down and then we'll talk about it once we get all the numbers here.
I think you're on 6.
6, related to protected interests of the beach. Number 7, related to protected interests of the dune. 8, related to protected interests of the dune.
If we can go back to 6.
6.
Once again, it has flood control in
Yeah, I'm
it.
writing 6 down. A lot of these have flood control, so do you want to talk about everything that has flood control?
Probably.
Okay, all right, that would be,
Because I think the answer is the same for all of them anyway.
okay, I'll just put an asterisk for flood control. I will note that there are several resource areas being discussed here: coastal bank, coastal dune, and coastal beach, and some of those may have different degrees of flood control, but we'll talk about all of them for you.
Oh, boy, it's almost all of them.
We'll just talk about flood control in those 3 resource areas. Okay, number 9, related to
Flood control.
now protected interests under the local regulations, not the WPA. It's flood control. 10 is, again,
Flood control.
okay. Number 11, this is related to the glacial and coastal history here. And I want to talk about that.
I figured you would.
All right, number 12. Number 13. I want to talk about that.
I figured.
Number 14, the water dependency. Number 15 is related to imminent danger. Okay, thank you.
Number 15, for the record.
I feel like
Thank
I'm
you.
at town meeting here. I just call them all.
Number 16, related to the emergency history of the project. Number 17, related more to the history and the non-compliance.
I do have a question on 16 and 17.
Okay, we'll put them on. Number 18, related to the phasing and segmentation into reaches. Number 19 defines the reaches. Number 20 and 21 defines the phases. Number 22 talks about sand nourishment. And number 23 describes the sand year. So I'm going to read out what we have so far.
You've been at town meeting too long.
It's 3, 6, 11, 13, 15, 16, and 17.
Take 17 off.
No 17?
No.
Okay. And because this is an open hearing process, I'm now going to go to the applicant to see if they have any findings they'd wish to discuss. And then we will also go to the public after that. Who would like to speak for the applicant?
I have my hand raised, Chip Nyland.
Go ahead.
So the one that I wanted to address is number 18. I
18,
want to make
yes.
sure what 18 has a provision that
Yep, I'm just gonna take them down and then we'll discuss them in order, please.
it's specific to the last sentence is what I want to explain, which is that the fines that reach one shall be constructed first. That's what we wanted to discuss.
Okay, thank you. Anything else? Okay, would any members of the public like to call into question any findings? Yes, please identify yourself for the record.
Thank you, Chair Engelborg and the Commission. RJ Turcott on behalf of the Nantucket Land and Water Council. I'd like to have number 22 added to the discussion as well.
22 related to sand nourishment.
Correct.
Just for clarity, Mr. Chairman, the one that, I apologize if he has the old version, that Mr. Nyland actually wants is number 20 now, because we added the 2 for the dune. So
I
sorry
still
about
have
that.
it as
It's not 18, it's 20.
Okay.
Mr. Nyland, did you hear that?
I did.
Unfortunately, you're working off an old version, and we will try to get the new version posted as soon as we can.
Yeah, we didn't find it. We didn't find it on the docket today, so.
Okay, it's up online. All right. Anyone else from the public wish to call into question any of the findings? Let's check the Zoom. Yes, Burton Balkine, please go ahead. Or bring him over.
Burton Balkine, I haven't actually had a chance to look at the numbers, but is there a findings about monitoring data that is in here?
In this section.
No, there are conditions in later sections related to monitoring, but there is no finding related to monitoring. Findings are kind of descriptive items and conditions are more regulatory items.
Thank you. I have nothing further.
Okay. Anybody else? All right.
Now we're back to flood.
So, yeah, I am going to go through the conditions one by one in numerical order, but before I do that, I'm going to yield the floor to Joe to discuss his potential concerns or questions about flood control.
I understand a flood in downtown Nantucket. I don't understand a flood at the bluff, Wisconsin Bluff. I mean, what does flood mean?
Water against the bluff.
So I can answer this and then I'll let staff also maybe help me out. But the reasons these protected interests are in the findings is because of how our regulations are written. And if you look at coastal bank, coastal dune, coastal beach, each of those resource areas has a list, actually every resource area has a list of protected interests that are significant to that resource area. For instance, in coastal bank, it says flood control, erosion control, storm damage prevention, wetland scenic views, and wildlife. But I believe what the staff did is took all of the areas that intersected and pulled out the repetitive things and put the protected interests in. Is that what you did?
Pretty much.
Okay.
Isn't it part of the standard language, those three phrases together?
Yes, although I will also note that how the regulations are written is it basically says when a project involves doing something in that resource area, the commission shall find that these interests are significant. That's not may find, that's not can find, that's shall find. So even if you don't personally believe that the Sconset Bank represented in this area leads to flood control, the regulations say it leads to flood control. That's why it's in there.
Hit the nail on the head.
Yeah, that's what I'm saying. Those three
Okay.
terms go together.
I think.
All right.
Both the act and the bylaw take away the choice for picking and choosing interests.
Yeah. You put the whole
It's
phrase
all
in.
or nothing.
Yeah.
So with that being said, do people still have any questions about 3 6, 11, or 3 or 6.
No.
Those are the flood control ones. Okay. So I think, we'll just check to see if there's anyone online here. I think 3 and 6 are all set. So we're gonna go to additional finding number 11 now. And I'm gonna read this out for the record. The finding is the commission recognizes that this particular coastal beach, coastal dune, and coastal bank exist in an integrated system of resource areas in a highly dynamic coastal environment, and that the coastal bank is comprised of mixed glacial till material with locally perched groundwater. So I think I don't necessarily have a problem with some of this. I mean, it's clear that it's an integrated resource system in a highly dynamic coastal environment, but how are we getting the information about locally perched groundwater and mixed glacial till? Do we have any data to back that up? And if so, if not, why is it in this finding?
So I'll try my best to answer this if it's all right, Mr. Chairman. So
Go ahead.
one part of it is we've been carrying this finding for this area for a bit, but it's also related to kind of the history of going through it where we've requested sediment samples over time from the coastal bank that have gone in to determine what that makeup is within the coastal bank. And with the locally perched groundwater relates kind of a long history and knowledge base of both test wells in that area and also groundwater breakout from the bank over time, depending upon what's happening. I mean, I'm certainly not married to any of the findings or conditions in this. If people don't like that language, we can certainly alter it or change it. I think the attempt too was to try to have something where the commission is kind of describing the area beyond just the interests and resource areas.
Okay.
Works for me.
Anyone have any questions? All right. Good. Thank you for that.
Do you want to run town meeting after this?
No.
Get rid of them this quickly?
Number 13, the commission finds that the project is proposed to protect pre-1978 buildings and essential public infrastructure, providing access and utilities for such. So
For such is a problem.
yeah. So my problem here isn't necessarily with the fact that the project is proposed to do that, but if you look at the regulations and the resource areas that are applicable here, it's a little bit more specific as to what is actually our regulatory responsibility. Our regulatory responsibility, at least under the Nantucket local regulations, is to use the minimum protection that will protect the pre-1978 buildings and the public infrastructure temporarily unless there is an alternative. And it's to protect them from imminent danger. So the other condition that I called out here, which is number 15 and 13, respectfully, I think we need to have these conditions or these findings be discussed in tandem, because the role of the commission in permitting this project is not to protect this bank or beach or dune indefinitely. It's to protect them temporarily from that imminent danger. Does that make sense to everybody? So I would personally like the finding to be reworded to reference that. But before we do that, we can sort of discuss the imminent danger if you like. Yes, go ahead.
As far as I'm concerned, it is imminent danger. That's a sort of a subjective term. Imminent danger could be tomorrow if Debbie hits us, or it could be 3 months from now. In the continuum of time, it's imminent danger, because as a kid, I remember the buildings that were another 200 feet out from the lighthouse, because I was in them. So to me, that's imminent danger as far as our lifetime is concerned. So, and I got historic structures, I got this, I got infrastructure, I got the lighthouse. To me, it's imminent danger. So I understand what you're saying, not in perpetuity. They're gonna have to figure out something.
Okay, go
I'm
ahead.
okay with, if you want to tweak it, I'm okay with that also.
So I think in order to characterize your thoughts in a way that is regulatorily sufficient, we can't just say we think it's imminent danger. We actually, as a commission,
Fine.
need to find what imminent danger means. We can certainly adopt the definition that, or one of the two definitions that the applicant proposed, or we could have a discussion on why those are not sufficient and find our own definition. Just for context too, I always like to say there's no precedent in the Concom, but finding an imminent danger characterization here is for this project in this filing only.
Right.
We're not going to say, okay,
It's not a policy.
imminent danger might be 40 feet.
Yep.
If you go to a project in jetties or Surfside, you can apply the same criteria. It's for this project based
Right.
on the history that's happened and based on the conditions that are there.
So what you're saying, in essence, is to flesh out that it's, I know it's particular, you and I, we all know it's particular, but to flesh that language out, to particularize it to this, given the history of this bluff, so it can't be used as a precedent someplace else, which
Yes.
may have a different standard going on.
Yes, like technically, or personally, I think that finding 15 should actually come before finding 13.
Okay.
It should say that the commission finds that the definition of imminent danger is blank. We'll have the discussion about what that is. Then there should be another condition that says, based on the definition of imminent danger, the commission finds, or maybe we don't find. We have to decide if our definition of imminent danger meets what the applicants are saying. So we either find that the structure is imminent danger or we don't find they're imminent danger. And then if we have a definition of imminent danger and we find that the dwellings and infrastructure meet that definition of danger, then we can have this third finding that says the purpose of this project is to protect the pre-1978 buildings and essential public infrastructure temporarily from this danger. Does that make sense?
Yeah.
All right. Does that make sense for the staff?
Yep. I knew something.
Does the applicant wish to weigh in on that?
Yes, if you're acknowledging me that I raised my hand, Chip
Yes,
Nyland.
go ahead, Mr. Nyland.
So I agree with you, Mr. Chairman, with respect to the fact that you want the language to track what's in the bylaw. I also agree with you with respect to the fact that these findings are not precedential with respect to other projects. I think where we depart is we believe that we have presented to you sufficient information so that you can find that it is in imminent danger. And by the way, we also agree that the word imminent should be in front of danger. We don't believe that you need to put a definition in there. That will be up to the commission. But we tried to look at that from a setback standpoint, from a linear standpoint. And then what we've provided to you is our opinion that it should be based upon what two storms could do. So, but we believe that you have sufficient information to find that the dwellings and infrastructure are in imminent danger without having to go through the construct of establishing what that definition may be. But otherwise, we agree that 13 and 15 should be discussed together, and that finding needs to track what the bylaw says.
Thank you. Members of the commission, are you aware, I know everyone's been participating and reading the NOI, but are you familiar with the definitions or the proposals that Mr. Nowen is making on how the applicant is defining imminent danger.
I could use an update.
I have it in here, but I don't know where, in my saved documents.
Mr. Nyland, for the sake of commissioners, would you be willing to rehash that for everybody?
I think it'd be, yes, and we would, but I think it'd be easier to have Dwight walk you through it because he
Okay.
was putting that together, if you wouldn't mind, Dwight.
Yes. Thank you, Chip. Mr. Chairman, members of the commission, what was written in the notice of intent first used the imminent danger standard that was established back in 2013 by the DPW engineers, consulting engineer to the DPW that established that the road should be it would be 25 feet to close the road from the edge of the road to the pavement, 40 feet for houses, and so therefore we have a 40-foot for house, 65-foot for road standard that was based on that memo from 2013. That was used in
None of us can.
28, 24, 26, 20, those prior orders of conditions. There was some questions during the public hearing process about the set established standard, the fact that it's not defined in the regulations what imminent is. So what we proposed as an alternative for the commission to consider is the fact that there can be multiple storms. We've seen multiple storms, hit the region, hit the island. The 2012, 2013 season, we saw 20 to 40 feet of top of bank retreat, depending on where we were on the bluff. So we've had seasons where we know that we cannot get, there's not enough intercedent time from one storm to the next to get any remedial repairs done. So we thought that another approach to defining imminent, since it's not in the regulations, is to look at the two-storm standard. And if we look at that, given the fact that in 2012 we had multiple storms, but we had one storm that lost 20 to 40 feet, so there is the potential for 40 to 80 feet in back-to-back storms. So those were the two discussions that we had, as Chip talked about, just a setback that was based on that 2013 memo, and then the two-storm event, which doesn't necessarily define a defined offset, but based on, some of the worst potential storms that we've seen, 2012, 2013, it could be 40 to 80 feet with the two-storm standard.
Thank you, Dr. Dunk and Mr. Nyland. Meredith Moldenhauer, please go ahead.
I just want to, did I freeze? Sorry, I think I froze for a second. Sorry. Meredith Moldenhauer for SVPF. I appreciate Dr. Dunk kind of summarizing.
Sorry,
guys.
Meredith, you have to speak up. The
gotta speak
sound in
into
here
it.
is really bad, so just yell or something.
Sure. Sorry. Is that better?
Yeah, as loud as you can be. Outdoor
Okay.
voice.
Outdoor voice. I'm good. I'm good with that typically. Sorry if I'm low. No, I was just going to say that, obviously I really appreciate Dr. Dunn kind of going into the specifics, and I went back and this is our 10th hearing on this. I do think we've had a lot of presentation on these issues. And I think some of you may know I'm a lawyer. I'm not as Chip is the lawyer as it relates to all these details, but I do think, it's kind of like the commission obviously can make a decision here. They don't need to go into the weeds. I mean, I remember sitting in law school that the U.S. Supreme Court said, pornography, I know it when I see it. Like at the end of the day, we're talking about imminent harm. We're talking about, are these homes in danger? And there's obviously we've lost, a lot of land. Dr. Dunk obviously provided all that documentation. We lost even land this winter and all those horrible storms. We just ask that you guys, look at the plain reading of the law and the plain reading here and can move forward with this and not, have to go into too much, take too much time, but hopefully can, walk through these, and we appreciate your review. Thank you.
Thank you, Ms. Moldenhauer. And although I hear what you're saying, I think a lot of the concerns that plagued the last permit for the previous GO2 project could have been resolved if the commission at the time had spent a lot more time carefully thinking about the conditions and vetting them. And some of the conditions in there were either unachievable or not grounded in reality. Some that the SPPF has vocally made their points to, and some that the commission has. So we're not here to just delay the process. We're here to get it right. And I know that doesn't always sit well with people, but that is my intent. Yes, Tim, I see you, but I want to say one thing. So thank you all for rehashing those proposals. I think the word imminent is very important for two reasons. One, because it is specifically the language that's in the regulations. And two, because imminent has a meaning. And it's not clearly defined in our regulations. That's why we're here having this discussion. But it's defined in dictionaries. And imminent means either about to happen or very likely to happen soon. It doesn't mean there's a potential that it might happen in the future. It means that there's a strong potential that it's going to happen very, very shortly. And I completely understand and agree with Dr. Dunk that storm seasons are highly variable and highly volatile, and we can't always predict them. But we can't be defining imminent danger based on the worst storm seasons in history. We can't be taking the 1% storm or the 1% flood risk and defining our imminent danger based on that. We have to be defining our imminent danger on what is likely to happen. So with that, Tim, go ahead.
I was just going to try and, had a hard time hearing a lot of this, but does this boil down to what some definitions are a distance from the bank to whatever, and they're suggesting not a specific distance, but the effect of two storms. Is that the summary of what's going on here?
Yes, there's two
Just to clarify.
proposals. The first proposal is a linear distance of 40 feet to houses and 65 feet to infrastructure, and the second is a two-storm process that is a little bit harder to define, but saying if the houses could be taken by, or the road could be taken by two consecutive storms, then it would meet the clarification or qualifications. So that is what the applicant has proposed. I do think, though, it is important that we have the discussion because I have concerns about both those definitions. I think it is good in theory, and also we could combine them and we could adopt both definitions and say whatever happens first could, or whatever is more likely. But I think it's good in theory to have a linear distance because it's a concrete, specific thing that is actionable and causes a trigger to happen. And I think scientifically, it's better to have a storm-based danger classification because that better mimics the reality of what happens in nature. So as a scientist, I agree with Dr. Dunk, and as a regulator, I think that the easiest to define definition of imminent danger is what we should be trying for. Yes, Mike, go ahead.
Thank you, Mr. Chairman. I agree with a lot of that, and I don't think anybody disagrees that dwellings in infrastructure are in danger. The imminent danger part, I think if we can put some distances on it, those are trigger points. 40 feet, maybe I'm just more reflecting my fear of heights when I'm standing up there on the bluff, but 40 feet seems awfully darn close to me. But I think putting a distance on it would get us there.
Yeah, so just, thank you. And just for, Joe, go ahead.
I also buy the 40 and 65 feet. It's definitive. You can measure it. And if you have two storms and you're at 50 feet for one house, or one lot, and then you have the first storm comes through and it's 35 feet, you should be acting on it because you're below the 40-foot limit. So why wait for another storm? That doesn't make any sense.
Sure. So can I ask people a theoretical question, not thinking about what exists on Baxter Road right now, because obviously the houses are in front of the road that contains the infrastructure. But what is your justification for why we would adopt a different linear distance from a house to an infrastructure? If we're saying that the distance that causes a risk is 40 feet, then it should be 40 feet for everything. So anyone have any thoughts on that?
Yeah, I'm concerned about defining the footage. We're in a very sort of unique situation out there on Baxter Road. Because even when the Bartlett cottages, she sat there and watched them, we burned one out at the end of Hummock Pond Road. We're going over, there was a whole nother road and a whole nother bunch of houses. This still, they're all gone now out there. And they just took down the other one that was left. This is a different situation. There wasn't infrastructure there. Granted, we had some septic pipes heading out into the bluff. But we've got a major road with major houses, with major erosion, dozens of feet back from when I was a kid. And houses missing, moved out of the areas, or they were able to move across the street. We've got substantial infrastructure because there was no sewer out there. Barely had electricity, but they all had tight tanks and other lovely things attached to them. And this is an entirely different situation with it's an imminent danger to me because of the infrastructure, because of the lighthouse, because of the houses on the east side, because of the houses on the west side, because of the potential lack of access. I mean, this is a lot bigger system than anything that I've seen on the South Shore that was on septics, that, barely had electricity, a lot of them had generators. This is totally different to me. So this is an imminent danger to me, imminent peril, I'm looking at one of the definitions, to me, because of the ramifications of not trying to protect it. So that's why I'm comfortable, but I'm not necessarily wedded to footage. I'm wedded to, this is the bigger picture, what's happening.
Thank
If
you,
that makes
Linda.
any sense.
It does make sense, but as I said, we'd have to define that in some way that people reading this document, applicants or the representatives reading the document, the staff interpreting the document, and members of the public reading the document could understand what it means.
But did what I just say, though, without getting into footage, because I think that's a dangerous thing to do, with all the things I just described that this bluff engenders being an issue, wouldn't that be enough to do as a definition, through you, Mr. Chairman, to Jeff, to flesh that out as to why this is very specific to that location? Because there's really not another location on Nantucket that has erosion where there is this kind of infrastructure. And where there's pavement, if you go out to Dionis, they'd move those houses back, but there's no pavement in most of it, and there's no sewer, and there's no water, and there isn't this type of conflagration of everything. Can't we make a definition of why we consider this different than everything else?
I would say no. I would say that's subjective, and that the definition of danger has to come from a risk, which needs to have an objective definition behind it. But
Infrastructure. Well, why don't we give him a chance to
go ahead
flesh
if
it out
staff wants to
between now
say
and
anything
next
about it.
meeting?
I'm just kind of thinking from all of that. I mean, my gut feeling, I mean, I like things that I can measure because that's how we check things and how we do. I mean, I'm willing to try to give anything a shot and give people choices and do a little research to see if it's been written that way somewhere else. I mean, I'm just kind of taking notes on what people are saying, and we'll kind of craft and compile
'Cause I
from
don't think
there
we're
for
going to solve
review.
it sitting here.
Yeah, so hold on one second and I'll go to you. So I hear what you're saying, and I think we could probably have the staff take some notes and then try to come up with a couple proposals for us for the next meeting and move on. That would probably be a better way to proceed, because I do want to get through the other at least findings today as well. Yes, would you like to go in?
No, I don't have a question.
Okay, Mike, go ahead.
Thank you, Mr. Chairman. And I'm not sure if you touched on it for a second, but were we saying structure versus infrastructure? So I see it as the structure is the building, the infrastructure is the road or
Utilities.
the utilities. So that's just how I'm distinguishing it in my mind. But I hear what Linda's saying, but I think it just, for the sake of everybody, the applicant included, that defining it by distance is the way we can get it figured out.
Okay, and just for clarification, the infrastructure is not the road, it's the assets in the road. It's the sewer, the water, the cable, all of that, providing service to the houses. If it was just an unpaved dirt road that had no improvements to it, that probably would not be considered essential public infrastructure.
Right.
I
That's
do
why
want
I'm
to
distinguishing between Dionis, Eel Point Road versus Baxter Road.
I do want to say too, this whole essential public infrastructure is a concern, because the way that the Wetlands Protection Act read and the way that the Nantucket local regulations read, there's a discrepancy in whether infrastructure is protected or not. In our local regulations, infrastructure is protected. In the Wetlands Protection Act, infrastructure is not called out as being protected. And then there's the problem that there's guidance from DEP indicating that local conservation commissions can create regulations that are more stringent than the Wetlands Protection Act, but not less stringent.
Yeah.
So I don't even know, I believe we don't even have the ability realistically to protect the public infrastructure. But that's another thing that I've wanted to ask legal counsel on, because there's no case law on that. And the only way that it could be case law is from a project from Nantucket, because it's specific to our regulations versus the Wetlands Protection Act. But staff, do you want to add anything in there?
Well, let me get a second.
So we did some digging the last time in kind of the origin of infrastructure and how it got in there. There was a belief for some period of time, the way coastal banks were being defined, that there may be the ability to have a local coastal bank only, and that's when infrastructure was added kind of to that specific case. But I will 100% agree that local regulations do not have the ability to essentially be an end around on state regulations. They can only be more restrictive. That being said, and I know this is never good to say this, but in findings and things that are there, I mean, you certainly can take, that into account. But I do agree with Seth that the way the state act is written is it's focused very much on the protection of pre-1978 structures. I think if you go back on the history of this project too, and even look at, kind of the genesis of the geotubes and into the emergency and superseding orders there, those were very much geared towards the protection of the homes. And while the threat to infrastructure was definitely understood and recognized, and temporary things were put into place to deal with that, essentially through those two documents, the state also said, figure out a plan for the road. And if you ever need to do something with it, we can talk about it then. But this is really focused on protecting the homes.
Thank you. So in that case, I see you and I'll let you speak, but in that case, I am definitely not comfortable permitting this project to protect infrastructure. I think that's a regulatory problem. And if we want to try to deal with it, to have separate permits for the state and local act, we could think about that. But I think whatever your opinions are on this project, we shouldn't be doing things that are in clear, clearly, not necessarily violation, but clearly against what the DEP guidance is. I think we should focus on the dwellings and just make our definition of imminent danger based on dwellings and not deal with infrastructure at all, because that seems like something that we're going to have legal problems over. Yes, Linda, and then Mike.
I think this is one of those things, we don't have to go 25 grand. This is one of those questions that we could vote without spending 25 grand again to ask George Pucci to weigh on that question, because we do have access to George Pucci or whoever they've got up there that's an expert in this type of thing. He's mostly zoning and HTC. So I think I would make a motion at this point to ask that question about the infrastructure, see what he can find up there, and through you to have Jeff ask that question of Libby, get the approval from Libby to ask that question up there, because we don't pay for that. We don't need to ask for money to pay for that.
Would you be willing to hold that motion until Mr. Mizzarelli speaks?
Yeah.
Mike, go ahead.
Thank you, Mr. Chairman. If we're protecting the structure, we have a really good shot at the infrastructure not being harmed. And so I'd be interested to hear from the applicant, or maybe Vince, if that's too general. I don't want to create a problem by making something too general, but if we could decide to come up with a definition to protect the structure, meanwhile we can get the infrastructure question asked, that might move us along.
Sure. Any other commissioners before we go to the applicants? Yes, Joe.
As I recall reading many of these documents, the 65-foot measurement is from the edge of the bluff to the road. It does not mention infrastructure. It says specifically road.
Yeah, it says road because it's been acknowledged throughout the lengthy permit history that the infrastructure is in that road, but it says road for ease of access.
Yeah.
It's
To get to them.
instead of saying 65 foot to every single cable and pipe that they would have to measure, it says road because we know the infrastructure is in the road layout. Mr. Nyland, would you wish to speak on this specific topic? If not, just hold and then I'll get back to you in a second. Or would Mr. Murphy wish to speak? He's here as well.
I raised my hand with respect to this specific topic. I think Dwight
Okay,
Duncan.
go ahead, and then we'll take Mr. Murphy after.
So this is critical to our project for a couple of reasons. First, Gordon Thompson has provided you with 100 years of data, more than 100 years of data that talks about the vagaries and the varieties of erosive forces that take place in Nantucket and especially in this area. So to identify imminent danger on a basis of on a linear basis just is not supported by what takes place. And it's not helpful for us to say, well, 40 feet is imminent danger, and then two storms happen, and then by the time the commission gets together and you refile, then you've lost the house and the infrastructure. So that's why I asked that you make a finding based upon what's in front of you that this area is in imminent danger without having to identify that on a linear basis. Second, as far as the infrastructure is concerned, the Department of Environmental Protection has protected coastal banks that include infrastructure and structures because you need the infrastructure in order to make the building habitable. So it wouldn't make sense to protect the building, but not protect the sewer and water that gets to the building. That would be, nonsensical. And the third thing is that this geotube process is structurally related to protecting all of the properties and infrastructure. If you adopt a 40-foot, you're going to have segments which will defeat the very purpose of having an elongated structure that's tied together that will protect the coastal bank. We all know what happens when you don't have returns on coastal engineering structures. They get eroded, et cetera. So to the extent that you come up with a whimsical number, you are inviting damage to the geotubes and ultimately destroying the purpose, which is to protect the coastal bank. And I don't know if Dwight has anything else to add, but that's what our concern is. This is a very important question to us meeting the performance standards under the bylaw and under the act.
Thank you. We're going to go to Mr. Murphy, and then Dwight, you can go after.
Thank you.
Thank you, Chair Engelborg. I want to echo a lot of what Attorney Nyland has said and to re-emphasize on top of what he said the importance of the road, not just for access, but also for egress in the event of an emergency, so that emergency vehicles can get to a house. If a house is in beyond a breach point, then there's a serious issue. I beg your pardon. If in the event that a house might have to be moved or have work take place on it, or in case the house itself may end up littering the beach or the bluff site and parts of it may need to be removed in the event of an erosion event that takes away part of it, you need to have public access to get to it, to deal with the answer, to answer the crisis. So in another way, it's not just about public access for the general public and the homeowners, it's public access for emergency response, on top of access to important things like the lighthouse. It's multi-layered. It's not just the layer of tarmac on the surface of the road and what's below it that's important to make the homes habitable. It's how we manage anything in the event of a crisis. Thank you.
Thank you. Dr. Dunk, please go ahead.
Yes, thank you, Mr. Chairman. Just to parse out a little bit of what you were getting at with the different. Can you hear me okay?
Sorry, outdoor voice, please.
You gotta
Okay.
speak
You gotta
closer.
shout. It's really bad in here.
Get closer to the
Sorry,
microphone.
yeah.
Okay. Can you hear me better now?
Yeah, as loud as you can be, please. Sorry.
Okay. As you have alluded to, you are looking to write an order of conditions in accordance with both the Wetlands Protection Act and their regulations and the bylaw. Under the Wetland Protection Act and the regulations at 310 CMR 1030, the standard is to protect pre-78 homes. There's no discussion in there about imminent danger or not. It's to protect pre-78 buildings. We have a series of homes, buildings that are pre-78 except for number 41. So all of the areas that are proposed to be protected by the CES, being the geotubes, are pre-78 buildings and therefore eligible for protection by a CES under the Act. The other piece that you're talking about is the bylaw relative to imminent danger. And that's where that standard comes in, is the bylaw. I think Attorney Nyland, Mr. Murphy, and others have brought up the fact of looking at this entire reach, that these homes are in danger. If the linear standard that was established, many of them are in imminent danger, but the need to provide a continuous line of protection is critical to protecting those homes that are imminent danger versus those that are in danger. Because if you have breaks in that line of protection, that becomes the weak point at which the coastal bank then erodes faster, causing more damage than protection. And that ties into the discussion of gap lots and why the DEP has allowed for the construction of CESs across vacant lots or in front of pre-78 homes to ensure a continuous line of protection. The notice of intent goes into that in quite detail, but there is cases specifically on this shoreline with 3115, where the DEP issued the superseding order of conditions for a continuous CES along the same length of shoreline that we're talking about for this notice of intent. So I think the standard that Attorney Nyland and some of the others have been talking about of looking at the area and looking at the project area in total, that the homes and the road, and typically if you look at the infrastructure bill, roadways are considered infrastructure. Otherwise, the roads wouldn't be part of the infrastructure bill. But roads themselves are infrastructure, as well as the utilities within them. So with that, the two-storm standard makes sense, but I think that the commission can make a determination that the project area is in imminent danger, and having that continuous row is critical to protecting all of the buildings that are in imminent danger, the road that's in imminent danger, and by providing that continuous connection is important to have a functioning CES.
Thank you. So I'm going to say one thing, and then I'm going to allow Linda to make her motion. But the last three speakers on behalf of the applicant talked a lot in depth about why they believe the application should go forward. But there's a difference between what an applicant wants and what is regulatorily able to be permitted. And even if we think that infrastructure cannot be protected under the performance standards of this definition, that doesn't mean that we can't allow the project to go forward. We would simply just have to apply a waiver that found that because of the issues with having non-contiguous lots, the commission finds that it's reasonable to have the CES over gap lots. That's also why at the beginning of this meeting, I thought it would be beneficial to have the council weigh in on this, but no other commissioners wanted that, so we're going to make our own decision on that one. But there are theoretical things that have been mentioned about what might happen, and that's different than what needs to be permitted based on how the regulations actually read. So I'm going to allow Linda to make her motion, and then I'm going to ask staff that we get a few potential options for defining imminent danger in front of us for the next meeting, and we recontinue the discussion then.
Okay.
Let her make the motion, and then we can have discussion if someone seconds it. Go ahead.
I'm comfortable with your take on the waiver for the gap lots, and I think that's something within our purview, so I'm not worried about that. I was going to make a motion to ask staff to make a request to get to Pucci on the issue of, how did you want to phrase it, infrastructure questions?
It's how you want to phrase this, your motion, so.
I had it in my head for about 15 minutes ago, and then it just left. The issue with infrastructure being a contributing factor as to why we would approve something. Would that pretty much cover it? Or do we have jurisdiction over the infrastructure as part of this decision?
Sure. Does someone like to second that motion?
Second.
Is there any additional
I
discussion?
think staff pretty much gets the.
Do you
drift.
have additional discussion based on that motion, Joe?
No, I don't.
Okay, I have additional discussion. So I hear what Ms. Williams is saying about wanting to go to the town council because she believes it doesn't cost money, but all legal services cost money,
Yes, but
whether
it's easier to get there.
whether they've been paid for in a contract that's standing with the town or special. I think it is bad practice to have multiple attorneys providing their own advice to the commission. I think we should stray away from that. I think we should either ask this to go to the special counsel that we have designated, or we should handle this on our own. But to get information from multiple different attorneys who represent different parties, I think that's bad practice. But there's a motion on the floor. I'll allow it to proceed to a vote if there's no further discussion. No, you can't. You can't. Sorry. I'm sorry, but any further discussion? Okay, there's a motion that's been made and seconded. We'll go to a roll call vote. Mike Mazzarelli,
Aye.
Tim Brain,
Aye.
Linda Williams,
Aye.
Joe Plandowski,
No.
Seth Engelborg votes opposed. That carries 3-2. Staff, do you understand the intent of the motion?
I hope.
Yes, I do.
Thank you.
I hope he does.
Do any members of the public wish to weigh in specifically on the imminent danger or infrastructure questions? And if not, we'll be moving on until the next meeting.
I think part of that, Mr. Chairman, to revise that was part of imminent danger to the infrastructure. I think that's where we were headed.
Do you understand that?
Yeah, and I can always rewatch this as many times as I need to.
Yeah, you knock yourself out.
Joe, do you have a question?
I do have a question. If we identify lots as imminent danger, what does that really mean to the owner?
It would mean to the owner that their lot is able to receive a CES, a coastal engineering structure on it, or to protect it because of how the performance standard is written, that lots that or it's not lots, it's buildings, structures that are in imminent danger and that existed prior to August of 1978 can be protected with a coastal engineering structure. So making a finding of what imminent danger means, and then also making a finding of which lots are pre-78. If we find a lot to be pre-78 and to meet the finding of imminent danger, then based on our regulations, the performance standards of our regulations, that lot is allowed to have a CES on it. If we find that the building is either not constructed or improved, or not constructed prior to 1978 or has been substantially improved, or does not meet the definition, I should say, and/or does not meet the definition of imminent danger, then that lot, that building, would not be allowed to have a coastal engineering structure in front of it to protect it, unless this commission finds a waiver, applies a waiver that allows that lot to receive a coastal engineering
As a
structure.
gap lot.
As a gap lot, or it could also be not a gap lot, it could be a lot that has a building on it but doesn't meet the imminent danger classification. It could be anything that doesn't meet the performance standard. If it doesn't meet the performance standard, it needs a waiver.
Okay.
Yes, please introduce yourself.
Good evening, Mr. Chair, members of the commission. My name's Dennis Murphy. I'm an attorney from Hill Law on behalf of the Greenhill family. On the issue of proposed conditions 13 and 15, I wanted to make three very quick points. 40 feet has been the number for over 10 years on this specific project in every order of conditions. And in fact, the DEP's superseding order, a copy of which I've brought. This is the superseding order issued January 28th, 2020. I'm reading from page 2. The homes on lots 61 and 59, that's Baxter Road, do not meet the applicant's proposed imminent danger criteria that dwellings within 40 feet of the top of the coastal bank need immediate protection from storm damage, as discussed in the notice of project change filed with MEPA. So my point is that there's an over 10-year history on this exact project where the yardstick that you've measured imminent danger, not just this commission and the prior commissions before you, but the DEP has been 40 feet. And in fact, 40 feet is the number in the NOI that was filed just 6 or 8 months ago in this very expansive project. This is not the time to move the goalposts and change it. And so I urge you to keep that same definition. Because I'm an attorney, I would be remiss if I didn't say this. It's not about 13 and 15. There was a suggestion that you could continue the time after the public hearing closes to issue an order of conditions. That is absolutely not the case. There is a SJC case called Oyster Creek. The moment you close this hearing, You have to issue an order of conditions because otherwise on the 22nd day, it will be deemed constructively approved and everything that we've done for the last 6 or 7 months is for nothing. So I wanted to make sure that was clear. My last plug is that we have Dr. Kriebel once again holding on the line, and I hope that there'll be a chance for him to address the commission when we're over. Thank you.
Thank you. He can have a chance, but I just want to note for the record that the superseding order of conditions for SE 483115 that Attorney Murphy is referencing has been provided to the commission and will be going into our record. So would Dr. Kriebel like to speak now on this topic or just would like to speak generally? Dr. Kriebel, I see his hand. Go ahead.
Yes, on this particular topic, I think I had not planned at all to talk about imminent risk, but it's a subject that's been addressed by others in the coastal field. I will say that counting 2 storms back to back with the same erosion runs counter to coastal science. We know that that does not happen. I will also say that normally in coastal engineering, we would look at the probability of these things happening. And, the probability of a 100-year storm occurring is, 1% this year. And if it happens twice, that's a 1 in 10,000 year event of 2 storms of that magnitude happening. So I think trying to use the argument of using back-to-back storms of a very intense magnitude is not really following good coastal science. I'll also say, having reviewed a lot of the data that Woods Hole Group has collected, that it runs counter to anything that they've ever measured. So I'll limit my comments on this topic there. Thank you.
Thank you, Dr. Kriebel. And my previous points also were about probability and what the definition of imminent means. It's liable to happen very soon. So
Climate change is going to make these storms 10 times worse, and that's the problem.
Mr. Balkind, would you like to speak on this specific topic?
Yes, Chairman Engelberg. I'd like to talk about proving imminent danger. And I think having a reasonable belief that there is imminent danger is different than it's different than immediate and present impending danger. It's saying there's no time to take evasive action, it's instead of it's impending, which I think I've heard some of the commissions say, well, there's impending danger, but it doesn't seem to be immediate and present. And I think according to what Arcadis, the consultants have been working on moving the road, that it means that there's no time to take evasive action. And obviously we have been taking evasive action. We've been planning on moving the road. So I think you need to drill down as a commission on this and really, really nail it, because it's going to help you, staff, and also future rulings by this commission, because I don't believe this is an isolated place. I mean, I think Cisco Road and Matica Road areas all have had pavement and infrastructure and have been either moved or we lost houses. So I don't think this is just an isolated incident. I really think you have to look at this in a bigger picture, and I think you really need to drill down on what imminent danger is. And I appreciate your time. Thank you so much.
Thank you, Mr. Balkind. Dr. Dunk, we'll take your comment and then we're going to move on because we're going to have to revisit this at the next meeting anyway.
You don't think we can get through all 50 things tonight?
No.
Thank you, Mr. Chairman. I just wanted to respond regarding the 2-storm standard, and I respectfully accept what Dr. Kriebel has said. However, in Massachusetts, for the last several years, it has been common practice for the Office of Coastal Zone Management, in commenting and responding to projects on the coast, to request modeling of back-to-back storms, such as a 100-year followed by a 50-year, and in some cases, back-to-back 100-year storm events, to understand what the effect of those storms will be on the coast and on the project that's being proposed along the shoreline. So I agree with you in terms of looking at the probability of large intense storms like that back to back, it has been standard practice from CZM to be looking at that as a standard. So I just wanted to just respond to that in Massachusetts, that's a standard that's been applied by the Office of Coastal Zone Management.
Thank you, Dr. Dunk. So what we're going to do is we're going to have the staff bring us some possible definitions of imminent danger to the next meeting. And right now, we're going to move on to the next finding, which is number 16.
I withdraw.
Okay, does anyone else want to talk about 16, the fact that it was undertaken as an emergency project? I want one word added to that. I just wanted to say to temporarily protect public health and safety, but I think that's a minor change. Okay, 18, related to the phasing and segmentation.
I believe that was those guys that pulled it.
Okay.
Well, no, I think he pulled 18 also, didn't he? It's 18 and 20, or 19 and 20?
Mr. Nyland looks like he's on the phone, but would somebody like to clarify which of the actual conditions you want us to discuss?
I know it's definitely 20 on our copy.
Yeah, it's 20A. I'm sorry. 20A.
20A.
I think
It was 18 on the other version.
71 to 119.
Okay, nobody cares about 18 then, so 20A. Okay,
Yeah, and just a correction, Mr. Chairman, shouldn't it be 71 through 119 Baxter and not 117 Baxter? Because Reach 1 goes 109 to 119, and when you go down to A, it says 71 through 117. It should say 119, because that's where Loretta's house is, isn't it?
yeah, you can go ahead, but
I'll double check the addresses because I remember when we typed this, the house that you're talking about specifically is not 119. 119 is vacant now, and I believe the way it's designed is the returns end before 119.
The only reason I'm asking that is when you look at 19, it says 109 to 119 Baxter Road, and then when you go down here, it says 117 Baxter. Shouldn't they be the same?
we're gonna check that.
I'll
at the staff
double check
level.
to be sure.
Okay.
So, Mr. Nyland, your comments were related to the second sentence, is that correct?
Yes, thank you. I just don't see a need for that sentence to be here. I don't think that we've talked at all with respect to the project as to what has to happen first or what has to happen second. There are decisions that are made out in the field in terms of what goes first, whether it's recovering Reach 2, going with Reach 2 and then moving south and then moving north, as opposed to being constricted to have to work just on Reach 1 first. It's never been discussed. We certainly have identified Reach 1 as a priority. It's very important. But to the extent that that has to happen first, there are a lot of challenges. We happen to disagree with the chair's feeling that or opinion that nothing can take place in 2024. We disagree with that and believe that it can. But if Reach 1 has to happen first before we can maintain Reach 2 or do any other work, then we won't get anything done in 2024. So we believe that that sentence, which we're not sure where it came from, will hinder the project and doesn't address the urgency that I talked about earlier this evening. So we just ask that it be stricken. It's not necessary that Reach 1 has to go first for performance standards or for any other purposes.
Thank you. I'm going to ask staff to do two things. First, put back up the reach map so that we can make sure everyone's clear what we're talking about, and then explain the justification for that finding, and then I'll let staff weigh in after that.
And I have a question.
Yep, after we have, I didn't write this condition, or the finding, so.
And by the way, I do have Jamie Feely, who's our construction project manager on, who can discuss with you how, we're looking at the construction sequence.
Thank you, and I will recognize Mr. Feely, but first, I just want to hear from the staff to see if we don't have to waste everyone's, or no, sorry, that's not right. If we don't have to go over the same things over and over again, if there's a reason for this to be in here or not, and maybe there's not, and we'll just take it out.
Thank you.
Sure, so maybe it was just poorly worded. I think the hopes were including it that way in the sense that when we reviewed the discussions and the findings that were there, that, and it's kind of interesting that this comes on the heels of the last discussion about imminent danger and proximity, that those are the properties that by proximity are in the greatest danger. And I think the hopes were to encapsulate that the houses that are in the most danger get action as a priority. Maybe we can wordsmith that a bit, but I think, and if Will gets the map up, we'll see. But I think within that reach, and I understand there, and I also know that, you know, later in the conditions, we talk about a construction plan and sequencing plan, but I think from rewatching the hearings and looking at it, there was a grave concern that those were in the greatest amount of danger and needed to be addressed from a bulk of the commission. Granted, there's been some turnover on the commission since then, so opinion may be different, but that's what we were trying to encapsulate.
Thank you, Jeff. I have a comment. I know commissioners have comments, and then we'll go to Mr. Feely, and then we'll go to Mr. Murphy. So thank you for that clarification, and I do think, as I said before, it is our role to protect the buildings from imminent danger, and doing it in the way that is most pressing and most imminent makes sense. That being said, I'll defer to other commissioners and what the construction manager has to say. Joe, go ahead.
Lot 119 is vacant.
Yeah, I've got it up here.
Okay, Linda, would you like to make a comment?
Yeah. I've thought about this. I thought about that phrase. I did go back to look at their NOI. And there was a whole section there, or it doesn't come up to me which section, I think it's something like 8 or something. There's a whole section there on the phasing tied to the funding, tied to all kinds of stuff without specifying which phase or which reach goes first. A lot of it depended in their NOI on fundraising, working with other entities, let's say the land bank, other things. But there was a whole section that would relate to this, because then I go back to new section, I guess it's new section 18. The commission finds that the project is being proposed as a phased project, which we all knew, and segmented into reaches, which we knew, as described in the project narrative and plan of record. So I went back and looked at their NOI language about how they're going to phase it and how they're going to fund the phazing, which is a reality.
So
And
with
I looked at
respect,
that, but I think you should, that should come back up.
Excuse me. With respect, I'm not going to allow any discussion within this hearing about financial considerations or fundraising,
Oh, I
because
know.
it's not germane to our
But I was
our
just looking at
process.
how
Our
they described
process,
it.
our process is trying to have the order of conditions be written to provide the maximum benefit to the resource areas. So anyone
All
else
right, well, let me finish my
wants to
statement
speak
then.
about finances, I'm going to cut you off,
Okay.
but Linda, you can go ahead.
In that paragraph, there was a lot of dealing with the phasing and how it was going to happen and how, the logistics of it. So I found that very interesting, thinking about this, because I too am primarily concerned with the areas that are in Reach 1. But I don't know how to get to Reach 1 unless we deal with Reach 2 and deal with Reach 3, which is attached to Reach 2, and then get to Reach 1. So if we were isolating this thing and only doing Reach 1, I'm not sure this project's going to happen to protect Reach 1. So I'm struggling with that issue. We can't talk about finances, but I'm struggling with the reality of how this is going to proceed, in what order it's going to proceed. So either we fix Reach 2, add Reach 3, and then go back to Reach 1, which attaches to it on the north side. I'm not exactly sure how this project's going to proceed at a reasonable level. I'm really worried about Reach 1 because that's where there are fewer people up there, but that's where I think it's closer to the road. It's going to hit those guys up there along with the lighthouse pretty heavily. So I'm struggling with the phasing and not allowing 2 and 3 to go and with 1, or waiting till 4 and 5 to go with 1. And how to phrase that in an order of conditions that you can't touch 4 and 5. Let them go with 2 and 3, and that fixes the one that's there and adds to it on the south side, and and then they can't touch 4 and 5 until they do start 1. They couldn't even throw a bucket of sand over the hill on 4 and 5 until they actually throw that same bucket of sand over 1. So that's what I'm struggling with, without just saying, okay, too bad, you got to do 1 first, and we don't fix 2. So, which takes me back to the enforcement order, and so there's a lot of things at play here, which I'd like to think about more for the next meeting, but I think some attention needs to be paid with exactly how this is going to proceed on a practical level.
Sure, thank you. And that's why we're here having this discussion. Mike, would you like to go?
Thank you, Mr. Chairman. My comment is, if I can get it back on my screen, a little briefer, but just the fact that, and it's more to the wording, the commission finds Reach 1 shall be constructed first. I believe 87 Baxter is the access point for dumping the sand over, which is in Reach 2. So by definition, you're working in Reach 2, and we want to get coverage back onto the existing geotube. So it just seems like a counterproductive sentence, as Mr. Nyland indicated.
Yeah, well, with respect, before they start dumping sand, they're going to have to bring the tubes down the beach from Hoyks Hollow and install them, pump them, install. I mean, there's a lot before you start delivering mitigation sand. But Mr. Feely, since this is your area of expertise, would you like to speak?
Sure. Thank you. I think just as we talk about a pragmatic, efficient approach to sequencing the construction phase, the delivery point has always been between 85 and 87, which also is just south of the current project. And so Reach 2, which is the current project, returns into the bluff just north of that delivery point. And so when we would start either any aspect of Reach 2 or 3, we're going to be bringing the material into that space. And I can tell you currently the conditions out for Reach 2, the existing project, is the tubes are uncovered. The area just south of the geotubes is the bluff has receded back to some degree. And so when you deliver that amount of material, I don't know how many thousands of cubic yards you're talking about before you get, to covering the returns of the existing project. It's a lot of material. And for us, what would make a lot of sense would be to tie Reach 3, which is south of Reach 2, into the end of Reach 2, run those geotubes, and then bring in 10,000+ cubic yards of maintenance or nourishment sand and cover the two of them together. Because if you don't start Reach 3 and you cover Reach 2, you're creating a bunch of unnecessarily going backward work when you then eventually get to start Reach 3. You would have to excavate out essentially that section of augmented bluff in order to make that connection. And I just, would urge everybody to consider the benefits of allowing Reach 3 to be tied into Reach 2 as part of getting that covered and in place.
Thank you. Mr. Murphy, would you like to speak?
That's where the choir rolls are.
Thank you very kindly, Vince Murphy again. So there's an issue in this. I have a directive from the select board that we must have the most risk covered in the best possible way. We need to address the imminent risk. My directive is for property and the road and utilities. But there are houses up in the north end in Reach 1 that are within 10 feet of the edge of the coastal bank. It has been in my understanding from the beginning that Reach 1 must go first. And if this is to change, I might have to take this back to Select Board, unfortunately. This is a different matter, and I'm saddened that our partners we couldn't resolve this before coming to the meeting, but this is the action that I'm left with. I may have to take this back to the Select Board if you want to suspend this question while I seek a response from the Select Board. That could be helpful.
Thank you, Mr. Murphy. It seems that the co-applicants on this application have some coordination they need to do. And I'll leave it at that, but Ms. Moldenhauer, you're welcome to speak.
Thank you. Yeah, I mean, okay. We have been in conversations with Vince Murphy on this, and we understand that this may have to go back to the Select Board, but we also, out of transparency with this commission, wanted to kind of learn from the past and talk about the potential for making this change with you tonight. And the reason why we're proposing it is as discussed by Mr. Feely and Mr. Nyland. And we also are hopeful that, if the commission finds it appropriate to approve the NOI, we want to make sure that we're put in the best position to really take advantage of the opportunity and actually get this built as efficiently and as quickly as possible. And so with that, obviously, what we've been told and what we believe is obviously the best would be to not take this out of, this is still the same phasing. Reach 1, 2, and 3 would still be in phase 1. But it would just be first priority, recovering Reach 2, which is the existing project, which we heard about at the beginning of the meeting, which we obviously understand is a priority from the town and from the commission. And then connecting Reach 3 and then providing Reach 1, so that way we can obtain the necessary momentum here and necessity to not just hopefully get your approval, but to actually see this constructed in time for the upcoming winter and to protect it against the imminent danger that exists on the bluff. So I'm happy to answer any other questions. Thank you.
Thank you, Ms. Moldenhauer. It's very confusing for this commission to hear two different things from co-applicants. So I would implore you to please have a discussion with your with your co-applicant and have a unified front for a future meeting, because it's very unclear as how you would like to proceed. I think with that, I'll take Linda's question and then we're going to move on.
I think something Meredith just said, I'm most concerned about Reach 1. I mean, it's clear, even from the 2003 aerials and the other things, the pictures that we've seen. Is there any reason, my question, you're going to have to answer it at some point, is there any reason why 1, 2, and 3 can't go at the same time? That's my question.
Thank you for the question. We're going to take that into an advisement, but we're not going to answer that at this meeting.
Right, they can't answer it now. But,
So I think what we're going to do is we're going to move on to additional finding 22. And then I'm going to ask for everyone's consent to continue this to the next meeting, at which we can start actually having some answers to some of these findings and discussing the actual project conditions. So 22 reads that the commission finds that all nourishment shall be done in compliance with the adaptive sand management strategy as proposed by the applicants.
I think that was Burton's, wasn't it?
This, I think, was raised by Mr. Turcott. Is that correct? Would you like to please speak on this? Introduce yourself and please tell us what your concerns or questions are.
Thank you, Commissioner Engelborg. Just to identify myself again, RJ Turcott for the Nantucket Land and Water Council. Before I get into my points here, I just would like to sincerely thank every single one of you. I know this is kind of like pulling teeth, but this is so important, and it's the only way to get this done properly, to make this happen, is this kind of attention to detail. So do it right. It takes as long as it takes. Regarding Attorney Murphy's comments earlier on that superseding order of conditions from 2020 and Jim Mahala's letter, I distributed that because Emily and I were diligently trying to highlight the main points, because that is DEP's advice to you as the commission. So the first ones are regarding findings 13 and 15, but regarding findings 22, I just want to be clear for the commission and those of you who are new and getting up to speed over the years that this volume of mitigation, this number, it didn't come from nowhere. It was really heavily discussed, and it's an average that the commission finally agreed on, this 22 cubic yards per linear foot per year. And DEP's opinion on it is, and I've highlighted this for you, due to the apparent success of the current mitigation plan in maintaining a walkable beach seaward of the existing geotubes and the substantial increase in project length, the department's SOC will require the current mitigation volume of 22 cubic yards per linear foot a year to remain for the expanded project. This was in 2020. The next piece is the department believes that due to the substantial increase in project length and unique circumstances of the project, the current monitoring plan of quarterly shoreline change analysis will remain for the expanded project. That's probably for the next meeting's conversation, but I did highlight that for you. And myself, from the Land and Water Council, as well as our consultant Trey Ruthven, worked out a letter we submitted today, which I'm going to distribute to you guys as well. I'm going to hand it to Jeff. I'm going to keep the paperclip because they're worth their weight in gold in my office, but these are for all of you, including John. So, and Trey is on Zoom if there are any questions about this, but this is, the main points are the 4 bullets on the second page, or the third page, referring to how this 22 cubic yards per linear foot came to be. So Coastal Planning and Engineering, Inc., which is an SPPF consultant at the time, determined.
Excuse me, hold on one second.
Yes.
I know you indicated this has been sent to staff, but has it been uploaded as part of the public packet?
No.
No, this was
Okay.
today.
All right, so I'll let you overview it, but we're
Okay.
going to have to not get too deep because
Okay.
it's unfair for people to not have access
Yeah.
to it.
And I got one to Vince as well. So basically, the 4 bullets are what I want everyone to focus on. This number is an established number. It's an average. And also the table 1, that is something I've referred to in prior letters based on the deficit. And it's something that if you're going to allow the existing project to stay on the ground, they really need to make up that deficit. And it is based on sound science and sound numbers. So with that, I'll let you guys review that. I know it was a late submission, but again, thank you for your time. You guys are amazing. I know that you're doing this as best as you can, and it's confusing, but I hope everyone can stay patient and we can hammer this out in a way that works. So thank you so much for your time.
Thank you. Do any members of the commission have any thoughts on finding 22 related to the sand nourishment?
It should be fleshed out more, maybe.
Yeah, I think we probably need to have a additional
specific.
discussion on that because this has been, I would say, the biggest topic of discussion in this project throughout its entire history, and it needs to have some additional findings, additional conditions related to it. Yes, Mike, go ahead.
Just for my clarity and everybody else's clarity as well, I believe the applicant is still at 22 cubic yards per lineal foot, correct?
The adaptive sand management begins with a initial construction volume of 22 cubic yards per linear foot, but it departs from the the expired project's conditions in that 22 cubic yards per linear foot won't necessarily be delivered annually. They're proposing an adaptive sand management structure based on the current conditions of the bank and the project itself. Dr. Dunk, would you like to speak any further on that?
It's pretty fleshed out in the NOI.
Yes, Chairman Engelborg, you were actually starting to, just summarize what this adaptive sand management plan is. We went into that in quite detail in one of the earlier public hearings where we where we discussed it and the amount of sand per reach. And as you were saying, is the adaptive sand management, just to remind the commission members in summary, is the project will be built with a template of 22 cubic yards per linear foot when it is built, based on the annual surveys of the template after the winter storm season. It will be determined how much sand has been contributed off the template into the littoral drift system, and then to establish how much sand needs to be is required to refill the template to 22 cubic yards per linear foot. And based on reach in the retreat rate of the bluff and the contribution rate of the bluff, that 22 correlates to just shy of 2 years worth of sand for reach 2, up to like 15 years worth of sand down at reach 4. So it's a large variation that there's a large amount of sand in the template to serve as the on-site stockpile to recover the exposed tubes, so that there's a large factor of safety built into this initial volume and then refilling to 22 cubic yards per linear foot per year. The superseding order of conditions that was referred to also included a standard that would allow the applicant to pursue a relief from that full requirement of 22 cubic yards per foot per year. But there was no quantitative standard for how that would be determined by the department to make that change. So I just wanted to indicate that there's a lot of thought process that went into this proposal. There is a lot of sand that's in the template that provides a large factor of safety, so that there'd always be sand available on this template to recover exposed tubes. Thank you.
Thank you, Dr. Dunk. And I will say, in the superseding order of conditions that's being referenced in relation to the adaptive sand management proposed, it didn't really, the language in the SOC doesn't really authorize that adaptive sand management, and it doesn't really not authorize it either. It reads that it is likely better practice to continue with the 22 cubic yards per linear foot based on the permitting history, but it does not require us to do that. It kind of leaves it open.
Correct. And there was a condition that allowed the applicants to petition the department to pursue that. But I think that is an order that was denied by the Conservation Commission. That was their superseding order, and it's been withdrawn. So I think we just should move forward with this order and this project to make a decision that makes sense.
Thank you. Any commissioners wish to weigh in, or should we just have a more substantive discussion at a future meeting? Yes, Jeff, go ahead. Okay. All right. Mr. Ruthven, would you like to speak, please? It's a coastal scientist.
SPPF for them. You hear me now?
Yes, please introduce yourself and say who you're representing.
Sure. Trey Ruffin with Sustainable Coastal Solutions. I'm here representing the Nantucket Land and Water Council. I wanted to address the adaptive management. If the commission takes the time to read Dr. Kriebel's report, you will see that at the current contribution rate, we are seeing erosion that is directly caused by the geotubes. And so by proceeding with an adaptive management where 22 cubic yards is not being actually provided now, we're going to exacerbate the problem, which then presents the problem is that we're not just compromising Baxter Road, but we're compromising the residents who are down drift. And so I'd like the commission to take a serious look at what the mitigation it has been required, why it was required, and how adaptive will actually compromise what's being done now. I mean, currently, with the existing geotube system, the applicant has not been in compliance for the last decade. The only year that they were compliant with the mitigation requirements was the first year after construction, so sand year 2014. So we have a serious issue when it comes to mitigation and what's actually being proposed. I think when we're talking about what REACH is to do also, we should look at, what the risk factor is. And then I can remind Jeff, back in 2013, the imminent danger criteria was all based on data that Woods Hole Group had collected over the years. And so you can revisit that to help refresh how that was developed originally.
Thank you, Mr. Ruthven. We do have Dr. Kriebel's letter on record. We do also have a response letter on record from SPPF, and I'm sure we all have our own opinions, but I think we're going to probably wrap up this conversation at this point. The last thing I'd like to say on the findings is that just because there's 23 findings on this page right now, doesn't mean that that needs to be the amount that we end up with. So if people have additional findings that they want added to the additional findings, you can send those in to staff, or you can say them now. But if you want to read through them and think about them and send more in, staff can put them on and then incorporate them. And then at the next meeting, we can talk whether we want them or not. Yes, Jeff, go ahead.
I was going to also kind of say the same, and if people go ahead, and I agree with Seth, right, there can be 23 findings, there can be 123 findings, there can be 3 findings. It doesn't, whatever the commission feels is necessary. But if people do go through, obviously, if people start in the next section below, if people have comments, feel free to send them in, and we can certainly at least sometimes add them in as like a comment out to the side, or we could mark up a version 2 to help get people's thoughts on the page and for folks to see what everyone's thinking. So we're, again, some of these are meant to have conversation come up. Some are ideas, some are mined from notes, some are mined from old documents from DEP and things. So we try to just compile and put forward, but we're definitely, if people think of things, don't hesitate just to email them in.
Thank you. So it's already been 2 hours and we do have other business today. So I will respectfully ask the applicant's consent to continue. But before we do that, I want to acknowledge that it's probably best to get this back onto a special hearing schedule. And I would ask the staff to send around some dates for us to get a list of not just August or September dates, but for the next couple months, scheduled hearings.
Sure thing.
Mr. Nyland, would you like to speak?
Yes, I agree with both points. I was hoping that you could actually have a special meeting next week, because I know it's tough on I've been on the other side. I've sat and waited for a long presentation, so I'm sorry about the people who are behind us. I do, however, need to correct, and I don't like to do that to counsel because he's very learned, but I think the commission needs to understand when the hearing is closed, that triggers a 21-day period for you to issue an order. You don't have to issue it that night. You have 21 days to issue it. If you don't issue it by the 21 days, you lose jurisdiction under the bylaw. We have the right to appeal the DEP, and you lose jurisdiction under the bylaw. So there is no constructive approval if we close the hearing and you don't vote that night. I think that's what I heard him saying. I just want to make sure the commission is well aware that after it's closed, there's 21 days. I do think that if we can continue it to the next meeting, I don't know when that will be, but it should be before your next regularly scheduled meeting, because we've got a little bit of time to get through here.
Thank you, Mr. Nyland, and I take your point. And I would say respectfully, the process issues aside, it's not good for either you as the applicant or for us as the commission to have to get into the business of closing the hearing and dealing with conditions outside the open process. We will if we have to. But I think that's going to end up with a lot of conditions that the applicant doesn't want. So, you have the right and the authority to proceed as however you wish, but I would ask for your consent to continue and to allow us to let this process play out. Thank you.
Well,
Yeah, hold on,
I
Mr.
did that.
Allen,
I
just
did
wanna-
continue.
Thank you. Just one, before we get to that,
So we need to continue to a date.
Yes.
So
You
You
our,
have to
our next
continue
meeting's
to a date
obviously
certain, is my
yes,
point.
we have to continue to a date
is to
certain.
April, choose many crickets,
Please.
August 22nd. I think for that, I think there's a lot of changing and wordsmithing from tonight that will definitely get to everyone, hopefully, and posted by the end of next week. And we'll have dates for the remainder of August, September. We'll just do through the end of the year for right now for alternative dates, and we'll try to square away location as well, because I know we're kind of under directive to be hybrid. It may be in the most beautiful building on Nantucket at 131 Pleasant Street. If that's available, we'll try to square that space away. I think we have a pretty set number for crowd, so I don't think we're worried about a ginormous 200-person crowd.
August 15th, the ZBA is in here at 1 o'clock, and they have 2 appeals, so
Okay.
that's
Yeah,
going to be.
well, we will resolve time and location.
Mr. Nyland, would you like to continue until August 22nd? You're on mute, unfortunately.
Sorry about that. Yes, if you're not going to meet on next week, then we would consent to agree to continue to the 22nd.
Thank you. This will continue until August 22nd, and I appreciate everyone's time and consideration today because it's a big project.
Did you want to start at 4 like we have been for them?
We'll deal with the dates, the times, and the meeting locations at a staff level, and they'll get us some opportunities.
Can I just say,
Yes.
until we get to special meeting schedules, there is conflicts for this room up until like 4 p.m. So 4 p.m. for the 22nd, I know is not possible. So we'll try to resolve that for the schedule from there.
All right, thank you. This is continued. That moves us on to notice of intent. We have Nantucket Islands Land Bank at
Thank you.
45 Nonantum Ave, SC 48 3769, represented by Rachel Freeman. And John, unfortunately, this was also opened before your time on the board, so you can't sit on this either. Rachel,
learning.
you're learning a lot, I hope. Rachel, come up and please introduce yourself.
Good evening, Mr. Chair. Is this where I speak in this room?
Yes.
Okay. Thank you. My name is Rachel Freeman, and I'm representing the Nantucket Islands Land Bank on a notice of intent application requesting permission to install a set of aluminum stairs, which is a removable set of beach stairs at 45 Nonantum Ave. 45 Nonantum Ave is most commonly known to the rest of us as Stones Beach. The land bank owns a gravel parking area there and kind of an extensive and popular beach. The wooden stairway that exists at this beach provides access down the coastal bank to the dune, but what we're seeing now is we're seeing significant erosion on the dune, which is creating such a steep pathway that people are having difficulty accessing the beach. We would like to have the potential to install a set of aluminum stairs as a second stairway if we deem it necessary in order to promote public access in this area. The resource areas that are on this site include coastal beach, coastal dune, coastal bank, land subject to coastal storm flowage, and it is within natural heritage estimated habitat. So the stairs themselves would be located within land subject to coastal storm flowage and a coastal dune, and they will be in the buffer zone to the coastal dune, the coastal bank and the beach. This is a water-dependent project, so to the best of our knowledge, there's no waivers required, and I'm happy to answer any questions that the commission might have.
Thank you. Do members of the commission have any questions or comments? Do any members of the public have questions or comments? All our in-house
There's so
public
much public.
left. Let's check the Zoom. Looks like none. Will, do we have everything we need to close?
Yes, we do.
Rachel, would you like to close?
Yes, please.
I'll make a motion to close the public hearing.
Sorry, Dr. Dunk, do you have something to say related to this application? You're on mute.
Not on this one. After you close it, please acknowledge me. Thank you.
Okay,
Okay,
All right.
motion to close the public hearing.
thank you for the motion. Is there a second?
Second.
All right, all those in favor, please say aye.
Aye.
Any opposed?
That's interesting, no roll call.
No roll call. Any abstain? That carries unanimously with John Schaefer not sitting. Okay, that will bring us to the next notice of intent, which is also Nantucket Islands Land Bank, Matacashan Valley Road, SC 48 3771, also by Rachel Freeman. You're up again. And John, sorry, but you're also not able to sit on this because it was open before your time on the commission.
He's getting educated. okay?
Getting educated.
Yes, thank you very much, Mr. Chair. The reason that this has been continued for so long, for your information, is that it took a while to process through the Natural Heritage and Endangered Species Program, and I will explain why momentarily. So Matacashan Beach is also a popular land bank beach. This actually is a property that's land bank with the Nantucket Conservation Foundation property immediately to the east. And we are proposing to facilitate public beach access again here in this area from the parking lots by mowing an existing path and installing a post and rope fence. This is something where we looked at a couple different alternatives. It's a highly mobile shoreline. We're seeing a lot of erosion in this area, and every year we go out, it's slightly different. We feel like putting in aluminum beach stairs at this point is tricky because it's so steep and so mobile. But a path back this far from the coastline might facilitate that access and allow us to retain this path for hopefully longer than one season. In this area, we have a coastal beach, we have coastal dune, we have land subject to coastal storm flowage, and as I mentioned, natural heritage estimated habitat, as well as BVW, which is bordering vegetated wetland on the Conservation Foundation property. Part of the reason that this required extensive review from Natural Heritage is because it is listed as piping plover habitat, and the Conservation Foundation wanted to work to restore some of the sandy areas on their beach at the end of the path with additional American beach grass. So as long as we were coming in and asking for a path, they said, now's a great time for us to look at restoring this. What they're seeing is sand moving into the marsh system there. It's continually blowing back, and by stabilizing that with American beach grass, they might reduce that wind drift. Natural Heritage was concerned about increasing or maintaining plover habitat. So the way that they've designed the planting protocol includes only about 30% coverage and sort of in small patches that would still allow areas of beach to be available for nesting if plovers choose to do so. So that's the long-winded explanation for why it was continued for so long. The path itself is within land subject to coastal storm flowage and a dune, as well as within the buffer zone to a dune and a beach. And this is also a water-dependent project. So to the best of our knowledge, there are no waivers required. We are happy, or I'm here and happy to answer any questions you might have.
Thank you. Do any members of the commission have questions or comments? I don't think we have any public left, but if we do, is there any questions or comments? All right, staff, do we have everything we need to close?
Finally, yes, I was getting really used to a bi-weekly continuance email since like May.
I'll make a motion to close the public hearing.
Rachel, would you like to close?
Yes, please.
Okay, we have a motion to close from Linda. Do we have a second?
Second.
Okay, thank you. All those in favor, please say aye.
Aye.
Any opposed? Any abstain? That carries unanimously with John Schaefer not sitting. All right.
Cruising,
Thank you.
Cruising along here.
Seth, real quick, Dr. Dunk has his hand up again.
Or did he
Yes.
never put it down?
Yes, Dr. Dunk, is it germane to one of these applications?
It is germane to item number 1 on the notice of intent list that was skipped for SE 483759.
We dealt with that already.
Yes, Dr. Dunk, there was a request for a continuance to August 22nd that was received prior to the meeting, and we continued that to August 22nd at the beginning of this meeting.
Okay, thank you. I had to step away for 1 minute for my daughter, so I must have missed that. Thank you.
Okay, thank you. Hopefully you have a good rest of your night.
Thank you.
Okay, so now that brings us to Laz Family Nominee Trust, 20 Wacoit Road, SE 483795. Mike Miserelli is recused, but John, you read in for this, so you can sit on this.
Hey,
So welcome to the table.
come on in, the water's fine.
And this is represented by Art Gasparo.
I don't know how-
Thank you, Mr. Chairman. This is the second public hearing. We continued the first one for response from Natural Heritage. Just briefly, you may remember this is the creation of the sand dune along the base of the coastal bank at this property, and we have received a letter from Natural Heritage essentially signing off with the condition that if work is to occur between April 1st and August 31st, there be a qualified shorebird monitor for that work. And I don't believe there was any outstanding questions from the commission, but I'm available should you have any.
Thank you, Mr. Gasparo. Do any members of the commission have questions or comments?
No.
Do any members of the public have questions or comments? We have very little public left. Staff, do we have everything we need to close?
We don't even have Zoom public, but yes, we do have everything that we need to close for this.
Art, would you like to close?
Yes, please.
I'll make a
Is there a
motion to
motion to
close the
close?
public hearing.
Thank you,
Second.
Linda. Thank you, Tim, for the second. All those in favor, please say aye.
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 Any opposed? Any abstained? That carries with 5 in the affirmative and Commissioner Miserelli recused.
Thank
I
you.
have to recuse from
Second.
Danielle's.
Okay. So next up, we have De Benedictus at 17 Sacagawea Road, SE 483798. Miss Williams is recused. I take it that Ryan Maxwell will be representing this project. Is that correct?
Yep, that's
All
correct.
right. Go ahead, introduce yourself and go ahead.
Okay, Ryan Maxwell from Bracken Engineering for the record. This notice of intent is for a septic repair on a very challenging lot. This property has a 2-bedroom house on it with a conventional septic tank, pump chamber, and leach pit. The leach pit is located in the northeast corner of the lot and sits on a coastal bank. And the leach pit has apparently failed to the point where sewage was seeping out of the side of the coastal bank. So a repair here is pretty necessary. In terms of resource areas on the property, there's the coastal bank I just mentioned that runs along most of the front yard, except for a small area in the northwest corner of the lot where there's a somewhat level area to park a car or two. And then at the base of the coastal bank and everything south of it is all land subject to coastal storm flowage. And then a little further south of that, there's a coastal dune, and then there's Sessachacha Pond. So all of our work here falls within one of those resource areas or a buffer to one of those resource areas. We've already been in front of the Board of Health and have received approval from them. And we did take advantage of every opportunity to reduce the size of the system and to pull it away from the resource areas the best we could. For the project itself, the existing septic tank and pump chamber will be removed and replaced with a Septitech denitrification system. Those tanks will pump the effluent up the hill to the highest point on the property, which is that level driveway area I mentioned, where we've designed a single leaching trench. We were approved by the Board of Health to reduce that trench size by 25% and to put it within 1 foot of the road and then 5 feet of the abutter, where 10 feet is usually required. So we really shrunk this thing down and jammed it into that corner the best we could. Let's see. So also part of this project, we have to relocate the well on site to achieve 100-foot separation from the well to the leaching trench. So if you look at the plan, the only place we can really achieve that 100-foot separation is to drill the new well just inside of that coastal dune boundary to the southeast of the existing house there. So then in terms of constructing this, there's really no easy way to do it, but we're proposing to construct a fairly steep ramp down the coastal bank to gain access to that lower area. The tank installs will likely encounter groundwater, so we've proposed a dirt bag dewatering system for that. Additionally, there's 3 mature trees that probably need to be removed just to facilitate some area to maneuver down there. So in place of those 3 mature trees, we're proposing 6 native shrubs. We've got silt fence shown on the plan, delineating the limit of work. And then the well install is going to create a temporary disturbance of roughly 16 square feet. So once that well is installed, we've proposed to revegetate with American beach grass. And once all the work at the base of the coastal bank is done, the temporary ramp down the coastal bank will just be revegetated in kind and reestablished as it exists today. And then we obviously need to request waivers for this project. So that's under Chapter 390-3FC, that the project has a long-term net benefit to the resource areas. And I think that's it. There's a lot here to digest, but can answer whatever questions you may have.
Thank you.
Yep.
Do any members of the commission have questions or comments? Does any members of the public have questions or comments? Staff, do we have everything we need to close?
Yes, we do.
Mr. Maxwell, would you like to close?
Yes, please.
Is there a motion to close? Thank you, Joe. Is there a second?
Second.
Thank you, Mike. All those in favor, please say aye.
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 Any opposed? Any abstain? That carries with 5 in the affirmative and Commissioner Williams recused. Thank you.
All right, thank you.
And next, we have Nantucket Islands Land Bank, Consu Springs, SE 48 3799. Rachel Freeman, again.
It's so weird to see you in person.
I thought I'd try it out.
She's here. She's
It's always on Zoom.
I know, just to see what it was like to be in person. Nice to see you as well. Nice to meet you.
go ahead.
Thank you. Thank you, Chair. My name is Rachel Freeman, and I'm here tonight representing the Nantucket Islands Land Bank on a notice of intent, which is actually because our previous notice of intent expired for invasive species management at Consu Springs. This is an area that we have undertaken restoration in and is a pretty substantial project, and we'd like to continue management. And as of right now, what we have for resource areas here are a BVW and a salt marsh. The reason for the BVW is really that we have an impounded marsh on the western side of the bike path, or railroad track, which was installed in the mid-1800s. And in that impounded marsh, and actually on the salt marsh edge, we have extensive amounts of Phragmites, Japanese knotweed, mugwort, and a few other invasive species. But those are our primary concerns. Prior to this year, we've been working with a company called Solitude, and we've been using a combination of glyphosate and imazamox to really try and set back the Phragmites as well as the knotweed. This year, we are going to separate the treatments into 2 different companies where we can really target the knotweed and the mugwort, and then the Phragmites separately. The 3 different herbicides we're requesting permission to use, not that we're going to use all 3 of them, but we are requesting permission to, if we feel we want to choose one over the other, are glyphosate, triclopyr, and imazamox. Glyphosate and imazamox are commonly used for Phragmites and knotweed. Triclopyr is also sometimes used for Japanese knotweed, which is why that is in there as well. All of these are approved for aquatic areas. And let's see, this is also qualifies for as an ecological restoration limited project because it's approximately 4.8 acres of treatment if we do the whole area. We published a notification in the Environmental Monitor on July 18th in accordance with that checklist. And this also requires a waiver. So we're respectfully requesting a waiver for invasive species removal within resource areas, as much of the work in this site will actually occur directly within the resource area. I'm happy to answer any questions, and yeah, thank you.
Thank you. Any questions from members of the commission? Anything from members of the public? I doubt it, but we have to ask. And I would just say, related to waivers for invasive species work, our regulations have a waiver that is automatically applied, so you don't really have to even request it, but
Interesting. Okay,
it is.
good to know.
We can talk more on that if you want, but
I would like to,
No.
yes.
yeah,
So
but
I'd like to
not- it doesn't have
understand
to
that a
be
little
today,
better.
but
Not
yeah.
today.
Not tonight, no.
Not tonight, but yeah.
Already brain dead.
I could even fill you
Totally
in
fine.
sometime, no problem.
Okay, great. We
So,
can catch up with Will on that.
I'm waiting for a motion.
Well, first, staff, do we have everything we need to close?
We have the NHESP determination, correct? It's,
Let me double check. I don't know, 100%. That would have been in Liz's inbox. She did not say yes or no. Oh, you know what? There is, I
You
can
have a
tell you the answer to this.
pre-existing.
There's the tiniest little speck of regulated habitat on the very edge, and it doesn't fall anywhere within the treatment area. So the vast majority of this is not regulated. Shocking, I know, but yes.
Okay,
So there we go.
all right. Would you like to close?
Yes, please.
Is there a motion to close?
Motion to close the public hearing.
Thank you. Is there a second?
Second.
I'll take Mike. All those in favor, please say aye.
Aye.
Any opposed? Any abstain? That carries unanimously. Thank you.
Thank you very much.
All right.
We're on a roll here.
Yeah, we're on a roll. That ends notices of intent. Our only amended order of conditions was continued until August 22nd. That brings us to the public meeting. We don't have any requests for determination of applicability. We have one minor modification. It's 256 Pulpus LLC at 256 Pulpus Road, SC 483644, represented by Art Gasparo. You can take it away.
Thank you, Mr. Chairman. I'm before you tonight for a residential redevelopment project where we had picked up and moved a house back and making various changes to the site. The plans have sort of been refined since the original approval, and this is to get the commission's blessing of the final plan that they hope to construct. The elements really have all been previously approved. They've just been moved around a little bit. The limit of work remains the same as was approved by the commission. The pool has changed in position from the original approval, but we've tried to show everything in a sort of we wanted to use 2 plans for you. This is the plan for sort of all of your structural elements with the buffer zones, and then there are very detailed landscape plans also included for your review. But again, we believe that it's within the scope of the original order of conditions and approval, and would be happy to take any questions, concerns, should you have any.
Thank you, Mr. Gasparo. I don't believe the landscape plans made it into our packet or were circulated to commissioners. Could
Oh,
you show us that and also circulate it?
Yeah, I don't have it either.
certainly. I just want to check, but sure, if you don't mind me sharing, I want to make sure I speak up. My screen, I have them on my other screen and,
We have consent from the staff that it's fine.
okay. So, here you have your, let me minimize it just a little bit. Plans were done by Mirka using my survey, as a base, which has the locations of the buffer zones and the pre-existing topography. Here you can see in the darker dashed double dash line, that's your 50-foot buffer zone to the vegetated wetland, and you have her grading scheme and the layout of the pool a little bit more detailed than what was shown on my plan. There is an addition to the structure, which is the original approval had a freestanding cabana, but they instead attached it to the house. So that is less of a structure and is actually a bit further away from the resource area. Here, and I think these were filed, but just in case, get these to you. And again, very detailed proposed grading plans, patio plans, keeping the patio outside of the 50-foot buffer zone, the walls outside of the 50-foot buffer zone. Planting plans are included. There's your the swimming pool details, and then lighting and planting. So we've got a lighting plan again outside of the all outside of the 25-foot buffer zone and mostly outside of the 50 even, I would say. And then detailed planting plans, all the species listed here for plantings. And that's it.
Thank you. I see some species on the planting plan that are going to be of concern for me. If you could zoom in.
Sure.
Just added to the list.
The Pennisetum, the fountain grass, those are currently undergoing my PAD consideration for invasiveness.
We certainly strike anything that is of concern
Yeah.
to the commission.
I'm sorry to do this, but I think it would be better to have you go back and look at this and then resubmit the landscape plan to the commission and then bring this to the next meeting because people haven't really had a time to digest this. Are you willing to do that?
Yes, but if we could, just to make sure I understand what is possibly of concern, is it just these couple of grasses, or is it really just want to be able to look at it in greater detail?
It's definitely the grasses. I also don't think there should be any non-native or cultivar species within, or I guess it's all outside the 50-foot buffer, but I really just want to look at it a little bit more if that's okay.
Okay, I will. The only reason I ask, and I'm not trying to just, is that if there's going to be something of concern, which I just heard 2 of the plants, and then I would like to talk to the landscape architect and actually try to revise the plan slightly before, your next meeting.
Thank you.
So it sounds like it's the Pennisetum, the 2 Pennisetums, and then to review the list for, of course, this is much more into Mirka's wheelhouse than mine, so I'm just going to convey this to her for any non-native species or cultivars.
Yeah, I think definitely that would be the course of action. My personal opinion, but maybe it's not shared by the commission, is that inside any buffer zone, we shouldn't be approving any non-native or cultivar species, but that's my opinion. But definitely the Pennisetums, which are likely going to become listed as an invasive species within the next decade. I don't want to see that on there. So thank you.
Very good. And maybe in case any other commissioners had any feedback for me, that would be helpful. And then I'm more than happy to continue it to the 22nd, Mr. Chairman.
Commissioners, any comments? Mike, go ahead.
Just that it would be helpful to scan the plan before the meeting. It obviously somehow did not make it into the packet. Thank you.
Anyone else?
Or the original, what was, there's some movement on this, on the site. What is the original footprint? What's changed from the original?
Did you hear that, Mr. Grossbaro?
Just the map.
Sure, I'll include the original, the overlay. Sorry, I'm going to stop sharing, Mr. Chair. If
Yeah, go ahead.
That's okay.
Go ahead. Yeah.
I'll include the approved plan as well. And overlay got very busy. But again, the building is in the same position, just has the other wart, but I'm happy to provide that other plan also.
Great. It doesn't have to get fussy, just so I can put them side by side.
Thank you. So would you like to continue till August 22nd?
Yes, please.
All right, great. Thank you. That will conclude minor modifications and bring us to certificates of compliance.
Can we do them all at one time?
I wish we could. We have a lot of ones that are honestly just invalidating orders, but I think we're going to take the two Frost Daisy Field trusts together at 74 and 76 Nantucket Road. These are SV 48, 2804, and 2805. I see Mark Ritz is on. Would you like to make a presentation?
Good evening, Mark Ritz representing the applicants at 74 and 76 Daisy Field Trust at Nantucket Road. Both of these orders of conditions were not acted upon. They have expired. New orders were issued allowing similar work. So we would just like to close these out. So hopefully it'll be very easy.
Thank you. Is there a motion to close and invalidate the two orders?
So moved.
Second.
I'm going to take Mike and then Linda for the second. All those in favor say aye.
Aye.
Any opposed? Any abstain? That carries unanimously.
Thank you.
Next up is Andrews at 4 Old North Wharf, SE 48 1619. Going back a little bit there.
Yeah.
That's Art Gasparo. Would you like to present on this one?
Thank you, Mr. Chairman. This is one of the old cottages down on Old North Wharf, Ms. Andrews' family, where they put new supports underneath it and did basic rehab. And we've done an as-built, and everything appears to be in compliance. We weren't involved at the time of construction, but everything appears from our inspection and our as-built to match the permitted conditions.
Thank you. Staff, have you been out to the site?
Yep, sorry, I was struggling. I lost Zoom for a minute there, but I have been out to the site, and conditions are as they were presented on the application.
So you recommend
And I
that we
got Zoom
could
back.
issue this? Is there any ongoing conditions?
There were no ongoing conditions for 4 Old North Wharf.
Is there a motion to issue the certificate of compliance with no ongoing conditions?
So move, Mr. Chairman.
Thank you. Is there a second?
Second.
All right, all those in favor, please say aye.
Aye.
Any opposed, any abstain? That carries unanimously.
Thank you.
We've already been here.
And now we'll go to Nantucket Islands Land Bank at Concert Springs, SE 48 3407. Rachel, if you'd like to present.
Or not.
Good evening. My name is Rachel Freeman again. Thank you so much. I'm here to answer any questions regarding the certificate of compliance request for the original Kansu Springs management, which included invasive species management of Japanese knotweed and Phragmites, as well as marsh master cutting of the Phragmites. And that order of conditions expired and is the one that just a few applications ago I was requesting a new notice of intent for.
Thank you. Staff, have you been out to the site and do you have any thing to say on this here?
All good, recommending issuing of the certificate of compliance. We don't have continuing conditions, and everything is going to be covered under the new NOI.
So move, Mr. Chairman.
Thank you. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed? Any abstain? That carries unanimously.
Thank you.
Thank you as well. That will bring us to Creekside Nominee Trust, 156 Orange Street, SE 483718.
Mr. Chairman, I was recused from this originally, so I'll recuse again.
Okay, Mike Miserelli is recused. Mark Ritz, would you like to present, please?
Yes, Mark Ritz from Site Design representing the applicant. This was an order of conditions permitting the construction of an at-grade swim spa adjacent to a building at 156 Orange. The work has been completed in substantial compliance with the original approval. Plan has been provided. I'd be happy to answer any questions.
Thank you. Staff, have you been out to the site and do you have a recommendation for us?
Yes, I have. I'm recommending we issue the certificate of compliance. I do have continuing conditions for this relating to the spa.
Please read them out for us.
And these will be conditions 21 through 26. So 21, all exterior lighting shall be directed away from the resource area and in compliance with Chapter 102 of the Code of the Town of Nantucket. 22, the pool shall not be drained or discharged into an area within the Commission's jurisdiction. 23, the pool shall not be chemically treated between November 1st and May 1st. 24, all chemical treatments shall stop 3 weeks prior to any draining or discharging of the pool. 25, the applicant shall provide the contact information for the company maintaining the pool. The pool company shall provide a 48-hour notice of any draining to the Commission with a plan showing where the pool shall be drained to. And 26, given the topography of the site, any pool draining that needs to take place shall be pumped by truck and disposed of properly at the sewage treatment facility or be in compliance with Chapter 361 of the Code of the Town of Nantucket.
What's funny is that I think this is one of the first ones we got into the lighting issue because of where it's located on the creeks. Because we talked about a lot of that stuff at that time because we didn't have that whole list at that point. But now it works out fine.
Yes, it's the standard lighting and pool conditions. Commissioners, any questions or comments? Would somebody like to make a
I'll make
motion?
that motion to
Issue with those ongoing
issue with those
conditions that
ongoing
Will
conditions.
listed.
Yep.
Second.
Thank you, Tim. All those in favor, please say aye.
Aye.
Aye. Any opposed? Any abstain? That carries 5 in the affirmative, and Mr. Miserelli recused.
Thank you.
Thank you as well. So next up, we have Quidnet Properties LLC at 84 Quidnet Road, which is SE 481788, and at 90 Quidnet Road, which is SE 481273. I see Paul Santos on, but I'm aware that these are just to invalidate the order.
Yep.
Paul, is there anything you would like to say, or should we just go to a vote?
He's asleep.
Okay, let's go to a vote. Staff, have you been out to the site, and are we ready to invalidate this?
I am extremely comfortable invalidating both orders. The work was not completed.
Is there a motion to close and invalidate both orders?
So moved.
Is there a second?
Second.
All those in favor, please say aye.
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 Any opposed? Any abstain? Those two carry unanimously.
Okay, fine.
Then that will bring us to orders of conditions. The first up is the land bank at 45 Nonantum. Will sent these out, and I'll request that he shares them on the screen as well. While he's doing this, this was 45 Nonantum was for the seasonal aluminum beach stairs.
Yep.
We just have the standard conditions 18 and 19 in there. Does anyone think we need anything else?
No.
Okay, is there a motion to issue the order of conditions as drafted?
So moved.
Second.
Okay, all those in favor, please say aye.
Aye.
Any opposed? Any abstain? So that carries, but John Schaefer is not sitting on that one.
Right.
So that carries with 5 people and John not sitting. The next is 45, or no, the next
That's a
is
shame.
43. No, we have the address wrong on here, but the next is 43 Matacasham Valley Road. So Will, on the permit that you sent out, it says 45 Nonantum. That needs to get changed.
That's what I was wondering. I just went, wait a minute, I just read 45.
Yeah, if you could put it up, that would be great.
Why did that say that?
It's a mistake.
Yeah, oh, there we go. Right map and parcel numbers.
All right, so this one was for the installation of the posts and rope fencing for the existing beach path, the mowing of that beach path, and potential vegetation with beach grass. There is a discussion of the NHESP. I see the additional findings here, and in addition to that, we're going to copy the whole NHESP decision onto this.
Yep.
There's kind of just the general conditions 18 and 19. Anything else anyone would like to add? Okay, John is not sitting on this, but is there a motion to issue the order of conditions?
So moved, Mr. Chairman.
Thank you. Is there a second?
Second.
Thank you, Tim. All those in favor? Please say
Aye.
Aye. Any opposed? Any abstain? That carries with 5 in the affirmative and John not sitting. The next is Laz Family Nominee Trust at 20 Wacoit. Mike Miserelli is recused.
I think John can sit.
John's sitting on this one. So this was for the installation of the sand foredune.
The numbering is weird, 18, 19, 18, 19, 20.
Yeah, the numbering is weird. We need it to be 18, 19,
How about that?
20, 21, and
21,
22.
22. Yes, it's AI. It's just invading. There was a thing on this one, though, about the shorebird monitoring thing between dates. Do I have that here?
So that's in the NHESP letter, and we're going to attach the whole letter to
Okay.
to that, so we don't have to restate it, but you are correct. Yes, Will, go ahead.
Just as a quick note, and I know Seth is pretty much already saying this, but any NHESP determination just gets automatically tacked
Attached.
on to the order of conditions, and that's good stuff for John to know as well, so.
Good. Okay. Motion?
Yeah, apart from the numbering, is there any other concerns?
Motion to approve with the numbering corrected.
Okay, is there a second?
Second.
Thank you, Tim. All those in favor, please say aye.
Aye.
Aye. Any opposed? Any abstain? That carries with 5 affirmative and Mr. Miserelli recused.
And I'm recused from Danielle's.
Thank you. Next up, we have the Benedictus, 17 Sacagawea Road. This was for the upgrade or replacement, I should say, of the existing septic system with an innovative alternative system. It does require a waiver because of the setbacks on site. But does anyone think we need any additional conditions or findings beyond that? Will, anything else to add?
Nothing else to add on that, sorry.
All right. Is there a motion to issue the order conditions as drafted?
So moved.
I will take Joe and Will on the or no, not Will, Mike on the second. All those in favor, please say aye.
Aye.
Aye. Any opposed? Any abstain? That carries with 5 in the affirmative and Commissioner Williams recused. And then we have Nantucket Islands Land Bank at Consu Springs. It's SC 483799. This is for the invasive plant management of the species that Rachel described using the techniques they described. The findings are there and the conditions are there. They're pretty robust, but they tend to be the typical conditions that we apply to invasive plant management projects.
Most of their projects.
If you could put it up on the screen, that'd be great. But does anyone have anything else that they would like to add here?
No, I've got it right here.
Okay,
I'll make a motion to
issue as
issue
drafted.
Drafted.
And
Alright, is there-
I did have to make a live edit, if that matters. I just
What's the
edited to
edit?
reflect the NHESP. That was a copy and paste goof of mine.
This does not require an HESP review?
Yeah, this does not, because it
Okay,
was that
would
piece
you
of it.
amend it to as amended?
Yep, as amended.
Motion to issue as amended by Linda. Is there a second? Thank you, Joe. All those in favor, please say aye. Aye. Any opposed? Any abstain? That carries unanimously. And that takes us to the end of orders of conditions. Thank you. Thank you, Will, as always, for drafting these for us.
8 o'clock.
And we don't have any extensions of orders today. Other business, I don't believe we have any minutes to approve. Is that correct?
That is correct, yes.
Okay.
Sunday.
Do we have any monitoring reports? No. Enforcement actions or potential enforcement actions? Anything, Will?
There's nothing that we need to bring up today, just as a super quick update, and I won't even mention anything but our last enforcement situation. The amendment has been sent out, so that clock has started, and we'll just be waiting to receive everything, but that's my only update as just regarding the summer house, but.
Thank you. So with that, we need to appoint a representative to the CPC. Is there any commissioners who would like to be our representative on the CPC?
John?
Yeah, I could do that.
You would like to?
Sure.
Joe, would you also like to?
No.
Are you sure?
Just
Okay.
one's enough.
All right. John, thank you for your offer. Is there a motion to nominate John as our representative to the CPC?
So moved.
I'll
Linda?
take Linda
Second.
and Mike on the
Second.
second.
Somebody.
All those in favor, please say aye.
Aye.
Any opposed, any abstain? That carries unanimously. Thank you, John. You'll need to go to the town clerk to swear in for that. And you can talk to staff about getting set up, but thank you for your service.
Sure.
Reports, we have CREC. Tim, anything to report? CPC, there's nothing to report because we hadn't had a member. NPNEDC, Mike, anything to report?
Yeah, so there's been 2 NPNEDC meetings since our last meeting. The first one on the 29th of July really just was, there was a little bit of a brief discussion about wind farms, but mostly NRTA ridership statistics. And then the discussion began on enabling legislation discussion, which is pretty interesting from the NPNEDC point of view. Seth, you know a lot about it, but for the benefit of the other commissioners, they're expanding the membership and where to appoint them from, and that discussion is ongoing. There was another meeting on the 5th of August that was essentially a workshop on how to arrive at what those final appointments are going to be, and that has now broken into a work group to finish that job. So that's where NPNEDC stands right at the moment.
Thank you. Next is Harbor Plan Update Committee. Linda?
We actually got through all the sections. Oh my God. And we are putting together a draft. We just got the goals given to us this past Monday, and we're going to have a public hearing again.
Yes.
On, you got to be there.
I'll be there.
Did you get a copy of the draft?
I have the copy of the draft.
Okay. We're having that meeting on the 19th, I believe, yes, Monday, the 19th. I think it's from 4 to 6 in here.
Will, it isn't here. There is a,
That's where we wanted to go.
yes, there is a flyer that was sent out. If you don't have it, Jeff definitely has it because he's on it. Can you make sure it's circulated to all the commissioners in case anyone wants to attend?
If they want a copy of the draft, we have it. Jeff has it also. But
Linda,
we're
will
at
you
that
annoy me
point.
tomorrow about that?
We're moving on.
Yeah, if you could just talk to Will tomorrow and make sure that he has everything he needs.
Okay.
Offshore Wind Work Group, we're not having a representative. So that brings us to commissioners' comments. Any comments?
Fantastic meeting again, Mr. Chairman.
Thank you.
I have
It
a
wasn't easy.
quick,
John, go ahead.
quick procedural question. One of the properties that came up tonight, I had done a lot of work on, but I didn't have anything to do with what was being
No, you can't
proposed.
sit.
So is that automatically disqualifying me if I've done?
You had a financial involvement with it.
Yeah, so we should really just refer you to the ethics training that you
Yeah.
need to
I mean,
take.
I read this stuff, but I wasn't sure.
And generally speaking, if you have a financial or familial connection to the property or the applicant, you should recuse.
Okay. That's what
Although
I
there
thought.
is a possibility to do a
1050. Whatever it is.
I don't remember the number, but you can make a it's not disclaimer, but you can make a declaration to the state ethics board.
It's like a disclosure.
No, it's gotta go-
Disclosure.
It has to go to the town clerk. But
It
it
has
has to
to-
go to the appointing authority, which is the select board. in this
It has
case.
to, in our case, actually go to the select board, and then also it needs to get sent to the state. But if you have questions about that, the town of Nantucket has an entire person dedicated to compliance. Maureen Coleman.
Okay.
You can get in touch with them. Our staff can help you out, or you can refer to the trainings that you did, but it's best practice to recuse if you think you even have a potential concern.
Yeah.
So please do that in the future.
I always get off of stuff that I worked on. I don't have any ongoing financial involvement,
I
but
mean,
I
this
get
was,
off
it
it.
was several years ago, but. so
Yeah.
I
it
still
didn't-
get off it,
Okay.
just out of safety.
It's up to the individual to determine their own decision.
Yeah.
It really needs to be a current financial or familial interest. That's what would automatically
Well, that would be easy.
cause you to have to recuse. If it's something in the past, you can make the disclosure and you could sit, but I'm not going to weigh in on the specifics. You have to talk to the State Ethics Commission on
I would
that.
just get off. Having been doing this for 40 years, I would just get off.
I just wanted to clarify it, so.
Yes.
thanks.
Because somebody could say there's an appearance of a conflict, which is entirely different. That's the second layer. So if there looks like I've sat on it or
Yeah,
worked
let's-
on it, I get off.
Let's just leave it at that, but there are resources available to you.
Yeah.
Any other commissioners' comments? Just quickly, I think Will might be saying this, but don't all leave at the end of the meeting because we're going to sign the orders today live.
No.
Yeah, he has all the.
so excited.
He has the orders ready for us to do the
We have to
signatures.
fix some of it, but that's not that
It's just the
page.
signature
It's
page.
fine.
Yeah.
Signature
I
page.
really despise
So
right signature.
before we adjourn, is there any administrator or staff reports?
Yes.
Go ahead.
Real quick, I think I'm going to send this out as a doodle poll. I just need to make sure that that's not technically breaking the quorum or
Open
something.
meeting
Anyway,
law,
but I have dates for potential alternate meeting dates for our procedural meeting. But I don't even know if we want to get into this right now after what we decided about SBPF. We're going to be doing alternate meetings, but this should be a single meeting. I could just throw these dates out in a doodle poll and hit you with the results next meeting.
Yes, my request is that we hold these off until we have a full commission again. So as long as
Well,
that's.
that's going to be the end of September.
It's going to be the beginning of October.
Yeah.
But as long as the dates reflect that, you can make sure that we all pick a date effectively.
And just for the record, I have 5 dates between October and December, and that's it. So it's not a hardy pool here.
Thank you. Anything else?
Just so you know, I'm not in New Hampshire from October 6th through the 12th.
All right, you can join in remotely if you need to.
I'm like, I've been off the island once in a year and a half, okay? But
All
I
right.
still chime in.
Can we
There.
take a motion to adjourn, please?
Motion to adjourn.
Thank you.
Second.
Is there a second. Thank you, Mike. All those in favor, please say aye.
Aye.
Any opposed? Any abstain? That carries unanimously. Thank you all for the meeting. This meeting of the Conservation Commission is adjourned.